Buenos días, good morning. Desde aquí,
Good morning from this auditorium at the District Administratiu of the Catalan government. Welcome to this fourth arbitration or consumer arbitration conference organized by the Department of Work, Labour and Law. For everybody following on streaming, we also want to say that we have simultaneous translation, Catalan, Spanish, and English, with also sign language interpreting straight into Catalan. So before we start this session, these conferences started back in the year 2000 as a space for reflection to see what are the different mechanisms to solve conflicts in an alternative way, those that stem from consumer disputes. And in this fourth edition, we have thought about a focus point, which is basically to discuss about the need of finding a system that can guarantee the rights of consumers in the face of all these companies offering basic services. We know what we're speaking about, utilities mainly, and phone, energy, where we concentrate most of our issues. So we have today, full day, and tomorrow as well. And also we have to say that these conferences are also paying tribute to Miss Marilo Gramon Fonbuena, who unfortunately left us a few days ago. Both personally and professionally, she is a true role model in the Catalan agency, consumer agency, because she's participated in all consumer conferences and also arbitration. That was her profession. She was president of the Arbitration Board of Catalonia for many, many years, from July 2010 all the way to this year. So we will be paying tribute to her. And let's continue because we have a full agenda for today and tomorrow. We have lots of things, so without further ado, we will now hear from the Secretary of Company, Jaume Baró Torres, who will be formally opening these sessions today.
Gracias. Benvinguts, bienvenidos. You are welcome.
Welcome, Director of the agency and the different speakers for these 2 days. Thank you so much for being here. And this is the fourth edition of a conference that is also assigned a maturity. And it is important to recall this today. Our current context, or in our current context, consumption is something very relevant. It is a driver for change, and we need to work to guarantee fair relations between companies, essential in a country that has everybody's needs in mind. This is necessary for society, for consumers, and for financial agents. The right functioning of the market requires a proactive attitude with all stakeholders so that their transactions of goods are respected. And for this reason, the government of Catalonia is committed to promoting alternative dispute resolution methods in consumption and consumer arbitration because it respects the rights of everyone. And arbitration is solving disputes alternatively in a very agile and free way, and takes into account the context of the relationship between the company and the consumer. Oftentimes, with the director, we talk about arbitration and whether it is truly related to the maturity level of a society, of an ecosystem. Could be markets, supply and demand. We study many different types of markets. And whenever there's market failures or the public sector needs to intervene, but also when we make the relationship more sophisticated, one of the ways of solving disputes between supply and demand, well, you know that arbitration is one of the most agile ways and less costly as well for a legal system that is overburdened. So if we can promote the mandatory nature of consumer arbitration in some spaces, some specific spaces of this relationship, I'm sure we will be favoring many different elements. This is a sign of maturity in a society. We will also help the legal system to be less burdened, and we will show the possibility of having arbitration and intermediation market creation. It is important, amongst other things, to see some things that we have as an agency. According to 2024 data, over 8,000 claims were managed on basic services and of amounts below 2,000 euros, of which 40% were solved, 32% through mediation, and only 8% with arbitration award. The other ones were archived. And you know that as a last resort, there is it's a last resort for a small amount, claims a small amount. So Miguel Samper in October presented the consumer arbitration modification project so that it can help solve small disputes that are under 2,000 euros. This is for autonomic application and state application, and the involvement of the state is very relevant for this to happen. And the Catalan Consumer Agency that aims at guaranteeing all consumer rights wants to be efficient and provide a response to all the scenarios and to anticipate all challenges, and such as the crisis with preferential rights and the telephone lines, the 900 telephone lines, online purchases, attention to vulnerable consumers, or tangible things such as now in November when we're more focused on consumption. So the responsibility of our agencies is to be flexible, adaptive, and to adapt to the future and the trust that citizens have given us. I think it's also important to have or to take into account that this conference can or is paying tribute to Ms. Mariló, as we were saying before. She's been president of the Arbitration Board of Catalonia since July 2010, a true role model to the agency, and this is the best tribute we can pay, remembering her here today. She was a person passionate for the defense of rights and proper consumer relationships. So have a fruitful conference. Thank you very much.
Doncs moltes gràcies, senyor Baró, per les seves paraules.
Thank you, Mr. Brau, for your words. And now, before we start with the sessions, we will have the pleasure of having an opening conference. We encourage you to be here and to stay. We will have Daniel Irinari with a suggestive title, Is it possible to transform societies? That's the title of his conference, and we'll see what he explains. He's a Basque research professor at the Basque Country University, and it will be a true pleasure to listen to him. So, Daniel, you have the floor. Good morning, everyone. I am very happy to be here in Barcelona with you. Thank you very much for your invitation. My question is it possible to transform society? But I'm going to speak in Spanish, if that's all right. Let's go to very basic and elemental elements that can help us open up our minds this morning. Since we're all quite sleepy, let's go back to basic concepts that help us understand how this enigma works in a society where we're all acting in a way or another. I will start with an observation. Why government? What is governance? Why are societies governed? Well, essentially because we are not satisfied with the natural course of things. To govern is to intervene, to correct, to modify, to balance. Social situation then, when left to operate on its own, would lead on to very likely catastrophical consequences and unfair ones as well. This is sometimes taken for granted, and I normally go to that Bertolt Brecht tale where he speaks about a government that is very much disappointed with the people it has, and they think about how to make up or create a new one. So this is very similar, or what we are doing is very similar to what we're trying to do. So bringing down society to make up a new one, or perhaps this is not so extreme. Perhaps there is an intermediate formula of a way of loving that society we are part of, and then not loving it in its current state at the same time, and wanting to have certain transformations. Does this make sense? And if it does, how can it be done? So, this slide is just for me to follow the order of my presentation so that we can have things a bit more organized. And we'll start at the beginning, this conservative reasoning, and I want to say a couple of things about conservative reasoning. The political cultures, the left and the right, or the so-called left and right, don't take that literally, because this is just, we all are a bit in the left and a bit in the right. We all have dimensions in which we are more conservative and some more transformative in others. So how are they different? They're different essentially in the fact that the left normally overvalues the transformation capacities of our society. So they're constantly speaking about transformation, thinking that that is much easier than what it actually is. And then the right is undervaluing the transformation capacity of society. Well, people don't want to do this cannot be done. And those who go for the left are more forgiving of the failures of government than the conservatives. They will not forgive the inaction of a government, the lack of courage. They do punish transformation failure a lot. And this is much related to political cultures, where we've been born, where we've grown, and we've been received our education, and this gives us a different sensitivity. Do you believe this is the case? Yes. Well, it could respond to a more or less general description. And therefore, these are two different ways of relating to reality. We relate to reality in two quite different ways. So why do we have conservative parties? Because they are needed by the people who are puzzled and bewildered by changes, and they need to have something natural, stable, something that has been always like that. And they somehow try to keep it, maintain it, and sometimes even restore it. Sometimes it's very comforting to go back to something that used to be. And for forward-looking or progressive parties, it's more focused on transformation, on more superiority as well, and wanting to achieve things that are better than what we have, whereas the right parties are more disappointed with what we have and disappointing with what the left wants to achieve. Sorry for giving this cartoonish description, but this is just to give you a framework so as we can understand what's relevant. So in a way, one of the dramas of the current ideological landscape is that part of the left has a very normative speech. This is what we need, transformation, and the left is not describing things properly, but they have excellent projections of a desirable future, whereas the right, at least theoretically, it describes things better, but has a very poor vision or does not take into account the normative plane of things and where we want to head to. I am no conservative, but I always like to wear my adversary shoes, and I believe that I'll speak about transformation of society, but I'll start by saying that it's better to not transform it and give in to those who say that it's better not to touch things too much. That mindset, there is a certain degree of rationality we need to understand, and well, we share it more or less. We all share it to a certain extent because we're all conservative, which is precaution and skepticism when it comes to changes. Everyone is announcing new things here. And, well, this is an attitude that can be defended with proper arguments. And I repeat, this is no heritage of those who perceive themselves as conservatives. In this world where we live with so much volatility, acceleration, conservatives go for inertia, continuity, and even slowness. And everything that entails change, and I do not need to tell you because you are in the public sector and you use your time to change things, but the conservative mindset will feel threatened. I'm sure you do lots of things and people feel threatened. I haven't finished telling you my idea and you're already thinking I'm going to steal from you. There's the pluralization of our lifestyles, immigration, feminism, and sexual diversity, and also how labor is changing in virtue of technology. So, left-wing people are less in favor of technology than left-wing people. So, this wants to show us the differences between both sides. We discuss and we have parliaments to see how the left or the right are right and just weighing their arguments. Of course, they both have arguments. So to make this conversation useful and fruitful, conservatives need to understand that what they consider to be normal is just a contingency that could be totally different. It's like having women in the kitchen or men occupying a public space. Well, that's just the result of historical contingency, and we could renegotiate all that. And that's how feminism was born, breaking away with historical establishments. Progressive believers need to understand that what has been traditionally done in a way, although even if it's not the final decision, needs to be respected as a powerful reason to not be changed for important matters and reasons. Public discussion would be better if we took these operations into account. I would tell conservatives about the limitations of governments and not going for transformation or political ideas or political programs of conservatives are avoiding social change or aspirations in the left can't solve the problem on how to make them become a reality. Have you thought about that? So, just a small nuance here. I'm not talking about extreme or far right here. I'm just speaking about conservative people. This is something that would take up a long time. I'm very respectful of conservatives, and I've read lots of mainly British thinkers we need to learn from, and I do not really respect the far right. It's something absolutely different. And I consider that we need to, well, being extremely conservative is an oxymoron. I told the former president of the Partido Popular, the People's Party, and he listened to me and he lost his position. I told him he needed to be a liberal conservative, and that has nothing to do with the extremism of some others I'm not even going to mention. So one of the problems that we find in politics nowadays in many different countries is that conservatives have this crisis of identity, a huge one, by the way, and they don't truly know what they are or stand for. It's not that social democrats know, but conservatives don't, and they're absolutely at a loss in that uncomfortable neighborhood they don't really know how to manage. Well, society of resistance. Our societies are very or more inert than what we wish, depending if we're conservatives or what we fear if we're progressive people. We're speaking about revolutions, but then at the same time, we are performing calculations of how things will evolve and develop. Algorithmic projections, business models, planning that continues to exist, and we might be exaggerating the disruptive nature of this change. I believe that routine is something very powerful, sometimes even too much, and it's sometimes traps these calls for urgent solving of matters. Now this has become a new routine because routine traps everything and devours everything. And it has many anthropological reasons I won't go into. But my fundamental hypothesis is that effective changes or changing something superficially doesn't really make sense. Or can I get a bit of water, please, since we don't have gin here? I'll just be happy with a bit of water. So if you want to have an effective, non-superficial change and shift, because look at the huge amount of things that we've done. The huge amount of examples I could give you of things that have been, fireworks here and there, and nothing has really changed. So who has designed this table? I mean, I can't even have my glass here. Okay, this is where I need to put it. Sorry, it's me. The problem is me. I couldn't really... This was made by a conservative for sure. My fundamental thesis is that balanced tasks and work can only take place if society is making them its own, and for that, society needs to understand firsthand, because we might not have explained what digital transformation is well enough, or what equal transformation is, and it also needs to accept it. I think we're not thinking too much, and this is just my small contribution this morning. What is the reason for hardly seeing any changes, the changes that we wish, or at least having less changes happening than what we desire? So also, why do we have a routine, or why do we have resistance? Whoever wants to change things, the first thing they need to do is to understand the reason for the resistance when it comes to changing things. That's the way of tackling things first. And also understanding resistance. We need to be sure and be confident that changing anything, they won't face any resistances, but if they do want to change some things, there will be lots of resistances in motion. So I don't need to be specific very specific about this now. But when one goes into a public space, when one tries to do something, they will find conspirators, protests, vetoes, different blockage mechanisms, opposed interests, and you really want to give in, don't you? And give up, sorry, but I'm not speaking about organized resistance to just block your program. It's something more simple than that. It's the power of inertia in a society, the power of inertia, of habits. In the end, we need to modify that routine. I can modify things superficially, but my true wish should need to be to modify routines. Green transformation now, for instance, well, as long as people's routine are not focusing on the proper way, that won't be achievable. So inertia is a self-protection structural mechanism for humans. We have inertia, routines, habits, because we want to protect ourselves. What from? Well, from the obligation, for instance, of making very important decisions at 8 a.m. We have protected ourselves with routines against that. But this comes at a cost. The success of any change is precisely building new routines. So how can we build a new routine? Not just exceptional changes under exceptional circumstances, but I'm only speaking about routine, replacing one routine with another one. Quite a hard thing to achieve. In the latest US elections, well, they've mostly, and I'm speaking about the last two basically, they've all been around what is considered normal. People were saying, well, this is not normal, these are weird. This was already, this changed when Trump said in his first opening speech that there was only going to be men and women, and we went back to the new normality with EU citizen sexuality. But that was very significant. I think I can give you lots of examples from the countries in the world, but we have politicians in the public space saying, but this is normal, and then you're telling me something else is normal. I'm not going to give you more examples because I don't want to offend anybody's normality, but that is how things are. But this is very significant because what is normal? Normal is what is usual, and well, we are in a world where certainly there's lots of things that clash against this normality. And now speaking of feminism, one of the resistances of feminism is that whatever is non-feministic, whether it's male domination or things of the sort, had been for centuries constituted as something very normal. And then suddenly we have some crazy, insane woman coming along to distort this normality that was just so comfortable, especially for us. So this is what happens. And there are technological innovations that are placing my job at risk and that force me to do things in a different way. There's a vicious circle that it's quite devilish, and we're basically seeing elites, or what elites wish as a transformation is not understood by people, by farmers, by yellow coats in France, and even worse, elites do not understand that people don't understand that transformation is necessary. How are they not saying that pesticides is just something, an abomination, or that we need to place a tax on diesel, which is a very polluting energy, much more than others. And those elites are saying there's a negationism or a denying of all these elements. I understand what this is, but sometimes there's this spontaneous resistance of many people to be subjected to a process that is highly distorting their normality. I'm not helping them or saying they're right in any way, but the climate crisis is, well, we've instantly thought that the problem is that people are not measuring their interests accordingly or appropriately. They're only thinking about the short-term interests, but not the long-term ones. Who would do that? Marx said in the Paris manuscripts sentence that made me laugh. In communist societies, people will forget their individual interests. And I'm thinking, what is a communist society? And then forgetting individual interests. I mean, that might be in the kingdom of heaven, but that's what he said happened in a communist society. And yes, we need to take into account the long-term interests, of course, but that's no easy task. I can do this individually in a society, but having an entire society systemically sacrificing an immediate interest for an interest that is more into the future, that's quite a miracle. And many things need to be done for that. So,
I think that there are too many people in this world, in our democratic societies, that handle some evidences that are not so clear. But how is it possible that they don't understand that this has to be done and so forth? Because perhaps it's not that easy to understand, or perhaps you've not explained it well. My proposal is that we have to transform things in a different way. I'm going to go a bit faster, otherwise I'm going to run out of time. The bottom line is that we have to think differently about the concept of transformation. We think very vertically in this transformation idea. I can change this. No one is going to recognize it. And if we talk about things that are superficial, that are easy, simple, fine. But years ago, you'll remember the indignation that there was. We have to change the productive model. That was a slogan, and around the pandemic, we have to come out of this better with transformations. That's what was being said. And there are colleagues that have minimized the transformations that we came up with. I was in Venice. It's the city of the plagues, and they have a foundation that keeps the memory of the city alive. And they had, 3 days we were talking about the pandemic and the island of San Giorgio. Fauci was there, Fauci, the person who was during Biden's time in charge of the fight against the pandemic. There was lots of virological, political, social aspects, and the first day there was a slide, and he said, It's not a matter of if there will be the next pandemic, but when there will be the next pandemic, because people, take it for granted that there'll be another one. And the question is if we're prepared or we're not well prepared. I think we're better prepared than we were last time, but we're still insufficiently prepared. That's probably the best answer. But we're talking about digitalizing society. We're talking about renegotiating the sexual contract, the relationship between men and women. We're talking about configuring a global governance. We're talking about foolish things. We're not talking about foolish things. We're talking about very serious things that are not going to be fixed overnight. President Illa is not going to suddenly say climate change is prohibited in Catalonia. Things don't work that way. So, another thing that we hear a lot from politicians, sometimes it seems that they forget this. The speeches are important, but speeches are not enough. We have speeches, and speeches can become a routine that is totally neutralized. My proposal is that whoever wants to transform something, first of all, has to understand the resistances, has to understand what the resistance in society towards that change are, and has to explore other ways of intervention which are different from the typical ones. If I haven't misunderstood, what you're talking about here is a situation of resolution of problems that's outside of the usual toolkit with which these situations have been resolved, and it's caused a lot of social harm because it's been stuck, shall we say, and so apart from the typical ways of vertical intervention, why don't we look for informal ways, decentralized approaches like the ones that have to do with incentivization or self-regulation, precisely to bring about those changes? Now, we could say that a transformation is a self-transformation. Either there's an auto-transformation, a self-transformation, or this is never going to work. We have to generate different situations that will allow society itself to understand, to accept, and to not see it as a burden, and that transformation is going to be compensated. It's going to be worth it. Now, I'd like to finish with an idea, and that is, well, a couple of ideas, actually. First of all, I think that we have to describe reality better. We have kind of a disassociation in which some people write down what reality is, and others say what they think reality should be. I was saying before with the right and left scheme, but this isn't going to work. It's not going to work. We have to come up with better descriptions of reality. We have the realists that have no aspirations and those that have aspirations, but they don't understand how things work. This is a disaster. The other idea is that transformation of society is very difficult, especially if the society is not with you. And that is why the main issue is inclusion. People have to feel included in that process. And when we do these things, we have to know that the outcome is going to be unforeseeable. An intervention in society, bring about a transformation of whatever. It's unforeseeable because we don't know how people will adopt these directives, those stimuli that we have started up to bring about that transformation. Okay, I could talk for hours and hours because I have the gin down here. Thank you for the gin, but I'm going to leave it here. Thank you very much. Thank you.
Moltes gràcies al Daniel per aquesta magnífica ponència. Haguéssim estat...
Now, we would have been listening to you for a long time. It's been a true pleasure. Well, it's not easy at all to talk about resistance, to talk about transformation. All of us have to change many things. We have to begin with individual change that he mentioned, he alluded to. And if I change, everything changes. So we have to go against resistance, against beliefs. It's much, things that are more complex than just that statement. If I change, everything changes. Yes, there's lots of work to be done, but listening to people like you, I know that we can make it all better, more inspired and more motivated. Thank you very much. And now I'm sure that you have some ideas that you have heard that you would like to talk to others about. We're going to take a quick coffee break. It's a 30-minute coffee break, and you'll find that we have breakfast set up for everyone. And all we ask is that you be punctual. Please be here in 30 minutes. We can meet here again and continue and try to stick to our program as much as possible. Thank you very much. I hope that you have all enjoyed the warm breakfast and that you've been able to share things. of the presentation that we heard before, and also in what we're going to hear in this second one. And we're going to do it with the first of our roundtables. In this case, the director of the Catalan Agency for Consumers is Isidor Garcia, and he will give us the following, well, ask the following question. Is it truly effective to use the judicial means to protect consumers? And I'd also like to tell you that we will have the participation of Francisco Javier Orduño Moreno, who's a university professor of civil law, Paloma Pellegrin, who is the public defender in Barcelona, and Pascual Ortuño, who is a writer. So if you could all join us, and Mr. Isidro Garcia, of course, and I will give him the floor. So a round of applause for this panel that we have here before us.
Bon dia, Se sent? Sí. A mi em perdonareu, però...
Good morning, can you hear me? You'll excuse me, but before beginning this panel, as would be more than reasonable, and if you allow me, I'll say this from the podium, I think that it's more than reasonable, and I think even mandatory for us to remember Mariló, that we have her very close to us in our minds. Before Lucinda mentioned her, but I personally, and given that I am the director of the agency, and she was with us for a year, but I'd known her for 28 or 30 years. We'd coincided in many things, and I thought it was worthwhile, with the permission of the speakers, the members of the panel, to just, before we talk about whether this is the topic of our panel, I'd like to speak briefly about her. I should have written this down because I didn't want to forget anything. And from this point of view, I think that the first thing to say is that Mariló has not left us. She is here. She's here among us because we can be certain that we will keep her alive in our memories every single day. Because her presence among us has filled us for quite a long time, of her warmth, of her bonhomie, and her consideration of others, her wisdom when it came to facing challenges every day, and her determination when it came time to look for solutions to any type of problems that arose. For that reason, today more than ever, in a conference such as this about consumer arbitration, in the Catalan Consumption Agency that's always been her home, well, Mariló is here among us. For that reason, thanks to her commitment, thanks to her capacity to establish principles, a school of thought, well, here she has her friends and colleagues that want to state that we'll always be with her in our hearts and in our memories. She will be present. Today is not the ideal moment for a tribute, because this acknowledgement should be carried out as should be done, and I'm sure that it will be done that way. But it's worthwhile to remember that yesterday we went to the first tribute to her in the ceremony of her funeral. As her daughter said, it was an emotional moment and unforgettable for many people, where she received the personal and human acknowledgement that she deserves. Many of us think that the best way to carry out this other tribute related to her professional trajectory has to do with maintaining her legacy alive. It should have the impact that we would expect. And we have the three areas, the important areas of her life: the university, being a lawyer, and always and above all, the world of consumption and the agency. For that reason, some of us have begun to consider the possibility, it's not closed yet, of course, to create a scholarship related to the world of consumption that would reflect all of her work. And I don't want to finish without I need to say that this last year, in which Mariló and I have coincided in the agency, there were two things that I cannot explain without her, and these were things that filled her with satisfaction. The first of these was the publication of the Catalan book of consumer law. It was the first one of the law applicable in Catalonia, and she was a co-author, and the other was the decision of the Department of Companies and Labor to take the steps to make sure that we had a mandatory resolution of the mandatory arbitration. And we have seen the participation, but until that moment, well, more than ever, it was Mariló's project. She has updated it, she has adapted it, she has led it, and she has been the guiding force behind it. And at all times, she has kept her determination of taking it to fruition despite the adversities. For that reason, some of us now have the challenge and not just the responsibility to achieve that, because it has become a tribute, a homage to Mariló. So humbly, I would ask you for your support to achieve that. And Mariló, you know that you will have you in our minds, and will take into account everything that you taught us. Thank you very much.
Bé, gràcies.
Very well. Thank you, and most of all, thank you to the panelists that are here with us, and that Elisenda Camps introduced previously. And I have had the good fortune of coinciding with them in the direct or indirect defense of the rights of the consumers and public management, and some of us continue to coincide in that area. And thanks to their knowledge and their trajectories, we thought that it was worthwhile for them to participate at this roundtable that has a very ambitious title. Is the protection of consumers using the law truly effective? This may be more particular for some of you, but I hope that you will also be able to suggest some thoughts, and I have others. And I would like for the audience to also participate and to share with us all those considerations or thoughts. Now, the first question was almost the title of this: is it truly effective, the protection that we have for consumers using the law? What is your diagnosis of the intervention of the law in these controversies, these conflicts that we have concerning consumption. Javier is not the only one that is seated here at the table, but Francisco Javier has had a great impact, especially during the period of the judicial crisis related to mortgages, and he has been an inspiration as a professor to many in this area of protecting the rights of the consumer. So, Javier, please. Hello, it is a pleasure to be here with all of you. Thank you, Isidro, for this opportunity. And very modestly, I knew of a part of the Ministry of Justice, the Supreme Court, and therefore I know the problems that people have. I am not a judge. There are problems that are very basic that are at the heart of all of this, but the response is that the administration of justice is important, but you know that it is a small entity within the general budgets of the state, and it receives a very small amount, and therefore it's an economic and structural limitation based on the resources that it has. So when we speak of this, Isidro talked about some questions that we have to break down and look at closely. We have to understand what effectiveness means, or efficacy. And this is the first step, because in the inaugural conference, when we talked about conserving, about transforming, about innovating, well, we talk about it as if it's the same thing, but the Royal Academy of Languages description says that it is to maintain things in the optimum state. So it's not a progressive, nor is it conservative. It is an initial starting point. If things are done they're not done correctly, they're not going to be useful. And to progress is basically to advance, to move forward. I think these are two realities that come together from a legal standpoint. And the legal framework has always moved forward. We can talk about Roman law, about intermediate law, all of those things can give you an illumination of where we've come from, and we can see that there have always been changes. We are like termites that are building and building, and in the legal framework that is the same. We can have a method therefore that I would say in the science of law, it is progressive, because the social reality is what basically establishes what we do. And now we are in a society of liquid value, and it doesn't mean that those liquid values have to have fluid values. They have to have those values, some of them that are novel, such as the principle of transparency, but solid ones. And how we talk about this in the legal setting. Now, we need to distinguish between efficacy and efficiency. Efficacy has to do with the methods, the tools that we use through which for consumers to bring their claims. There is no doubt there. The arbitration system is infinitely better. It's a system that has very reduced costs. It's a system that acts like a complementary system as an escape valve for the general judicial system, and it's a system that more and more is becoming specialized. Perhaps we would need to harmonize it and to have a very clear doctrine of what the decisions of those arbitration systems are, to bring them all together and have a corpus, the appearance of a consolidated doctrine. That would be great. But from the point of view of effectivity, I have no question. The other one, which efficacy also affects the mental scheme, because efficacy has to do with the structural makeup of the norms, of the regulations. The consumers have rights, and these rights have to have a way to make claims, and this has to be recognized legally. If this is not present, it's very difficult, and there have to be certain applications, what we understand as actions, instruments, so that it is possible. These are possible and it can be improved. Remember, when I was little, I began to study. And our civil code kind of glossed over this with an article, but obviously compliance too. We have to see defective compliance, and we have seen that the recognition of rights or prudence, legal prudence. Sometimes prudence is slow, but sometimes prudence is indecisive. So if they're going to run you over if you don't run, well, you know, we have, with this, we see that to continue along these lines, I would say that in this idea of efficacy, it is true that is unsatisfactory because we have a clear normative reference and we have a consumption legislation that's clear. We have general conditions from 1989, which is completely obsolete. It really is of no use whatsoever. One of the main factors of protection that we have is when there is no way to, in the legal setting, there's a situation of inferiority where no one can negotiate anything. What do we need to ask from a small SME or from independent autonomous worker? Well, sometimes their conditions are worse. So the law of general conditions was created in '89. It does not follow the German or the French law, so it leaves these small entrepreneurs out. And it has the innovation of '93. There was a transformation. There we saw a transformation. But be careful, a transformation in the law setting takes its time. It's like when you go to a cave and see the stalactites and the stalagmites. Well, you know, you can't see it growing because it takes years and years and years and centuries. So everything requires its time to mature. And it's true that with artificial intelligence and digitalization, we are going very rapidly. Technology is imposing its rhythms for the regulations, because even if they're prospective, we don't know where things are going to go in these new technologies. But it is true that in the legal setting, it's a bit slower. And I'm going to finish with this. I think we would need a reflection, a deep reflection on this, and that would help us in this arbitration system. We would have to look at abusiveness, what the parameters are of abuse, and it doesn't only depend on the general system, but we would have to look at the contraction of the clause of abuse in hiring and in contracting. And the last two rulings from the court number one, and these are rulings that, in my opinion, if the parameters are these, then the parameters that orient this, they denaturalize the clear jurisprudence, not the parameters, but the jurisprudence of the ruling of July of 23, where this was 5/19. 2024, so that the consumer could understand what that was made of. It's not an index. It's not like the Euribor. You had to explain to the client that what you're applying as an index was a TAE, and you had to explain, as the Court of Justice said, we had to recommend to the financial institutions to apply a negative differential, because otherwise the introduction of a TAE as an index was going to distort the market. That's a ruling, 1009 120 that is based on the obligation of the financial entity to mention the Circular 5/1923, and it's not 2023. And I'm going to finish with this, but in order for if anyone has a doubt, all you have to do is to go to it and see that the person that signs that is. It's a circular from the Bank of Spain for financial entities, and this is carried over to the consumer. So a consumer can accept as a recipient a letter where they do not appear as the recipient. It is the banks and not the consumer, and the ruling of 23 says that there cannot be a legal investigation to look at all of the aspects of the Bank of Spain, even those that are destined, that are aimed for the financial sector. So in this area we need normative structures and tools. And when we talk about transformation, it is the executive side that does not legislate that's at fault. And this could have been resolved in many ways using the regulations. There are many ways, but what we cannot expect is we cannot question the jurisprudence of the Supreme Court for having done things and that it shouldn't have had to do because the legislator had not done them. So it seems that these issues of consumption are not that important at the legislative level, and maybe we'll spend another 30 years without a law of general conditions of 1989. Let me repeat the question. Pascual, I am very proud to say that as he has been in charge at the Department of Justice of this government, of not only the judicial power but also the executive power. So let me ask the same question. Pascual, do you think the protection of consumers is effective when it's done judicially, and how do you see it? Well, it's very difficult to answer your question directly, but I am going to try by making the abstraction that I have been trained in Murcia, but I live in Catalonia, so the answer would be one from Galicia, a Galician answer, and that is, it depends. The topic is so complex that how can we improve this? Well, it depends on many factors. I think that we are living a transformation of our society which is going extremely fast, and of course in the area of consumption that's also the case. It's something that is going so quick. All of the legal agents, all of the legal operators, the laws that can be published, they are outdated in a very short time. So from the point of view, from the perspective of efficiency, I would say that it's important if the conflicts, the consumption conflicts are collective, then perhaps there is a greater importance and it would be more adequate for them to be resolved by the ordinary courts. Why? Well, because this would clarify, logically, as Acuña says, as he said before, with laws that are clearer than the ones we have. And I think that we could have a response that's more efficient. Fortunately, with the law of 2023, the witness plaintiff has I think it's 6 million claims that there are. It has allowed us to reduce that number. We have to take into account that in a statistical way, the number of rulings that have been there were approximately 300,000 last year, the rulings, but in litigations, we are over 3 million. And if we go to complaints about consumer issues, well, what we're looking for in ordinary legal framework is to have sentences that are clarifying. Ordinary justice is fine, but if we look at the utility for the consumer, well, then they're not, because it's a disaster. We know how things are with the law. It perhaps it's not enough just to push a button. It's not enough just to be familiar with the law, but we need for all of society to somehow become aware of the lack of mechanisms and that we need changes. I have an experience, a personal experience. Orduña was talking about Roman law. I remember actio aquea puvia arcenda, because this was in an oral exam from my professor of Roman law. For example, sending rainwater to your neighbor's house was something that was dealt with in Roman law. And it was a constructive effect. It took 17 years to reach the Supreme Court. And if we go to the right of consumption, we're going to have the same response. So most of all, even if we want to change the laws, modify the laws, even if we have the doctrine of the European Union Court of Justice that gives the Spanish Supreme Court, they have slapped them on the hand several times with the famous problems with the mortgages. Why don't they invent the sweet mortgage? But in any case, no matter how hard we try, we are lagging behind. And another example, my last experience was now as I was preparing to retire. Well, I had a small pension fund, not a lot because I'm a judge and, well, we don't make that much, but I was called by the bank that wanted to offer me another bank, and instead of giving me 0.5%, they're going to give me a 3.70, and I was very happy about that. But when I said yes to the advisor, they call them advisors from the bank, then he said, all right, well now, in order to meet the law, to comply with the law, I'm going to ask you some questions. And I had to undergo an exam, and he asked me if I understood each one of the points. I am a jurist, and I've been in this for many years. Well, it was hard for me. It was hard to follow what this agent had to say, but I think it wasn't effective. It is more effective for the conversation to be recorded when you're going to sign a mortgage. For the conversation to be recorded, we have to think of other methods that are perhaps a bit more active and a bit more realistic, because the majority of people, I believe, I mean, not even with that exam do they understand. Not even when there's a notary public that is being recorded and that is explaining and it takes an hour and a half or 2 hours for a deed to be gone through. People get tired of listening, they don't understand, and you're going to explain each thing. We would need to think of other formulas. Positively, at the individual level, well, I have a different experience, and the other day I changed my contract for television I went to a new company, I'm not going to say which one, of internet, and they sent me a device that it didn't work. They hadn't explained it to me correctly, so it didn't work for me. So on the phone, I told them that I want to talk. They said, no, we have a computer system for this. And I went to the computer system, I asked questions, and it would say, I am Judith from La Coruña. My colleague, and all of this, it was a machine. Judith was a machine that you have. I was told that you have a problem with this or with that, and I explained the problem. When I explained the problem, I was then passed on to Raúl. He told me he was from Alcalá de Henares. I said, well, nice to meet you. But in the end, he solved it. They resolved the situation. After telling them and explaining things several times, they resolved the situation. Is this the future? Well, most likely it will be the future. Now, it's difficult for us to trust in self-regulation on the part of enterprises that provide services. And I am in favor of that being more serious, formal, especially looking at the public, the administration. Many of the things that we use depend on the public administration. And how do they carry out their arbitration? That's the consumption agency. That's true, and I'm going to finish because there are more questions. Arbitration has its pros and cons. If I were a lawyer, I would never recommend an arbitration. Why? Well, because if it doesn't come out well for my client is going to be angry with me. Why didn't we go to court? And why am I saying this? Well, because I am very much in favor of another method or other methods, especially mediation in the area of consumption. When I was a general director, and that's when I had this experience, I was very disappointed because we began the first Catalan law for mediation, and we reformed the one that was from 2001, and the state law in 2011. And from the department that I was leading, I had the responsibility of mediation. Well, I wanted to get into mediation consumer areas. They said, no, not at all. Consumption is different. And there has been a misunderstanding. I was fortunate enough to have been sent as a representative of Spain to the negotiation of the European Directive on mediation. And when the mediation of consumers was excluded, not because they didn't have the same principles, but rather to create a law that was specific and better and broader in scope. They were not two different areas, different scopes. Well, this allows for hearing the reasoning of the complaints of the consumers, and we never know if at any moment things can go to court if that mediation does not satisfy the consumer. As far as the arbitration, the mandatory arbitration, well, there is a trend there. The last time I was at a family issue at the international level, I know there are countries like Holland, like the Netherlands, that are using mandatory arbitration in the final phases of divorces. In other words, in the splitting up the common possessions. And that's also true because if it weren't for that mandatory arbitration, there'll be a divorce, and there's not the availability of the goods that that person has bought in that matrimony until they've been married 3 or 4 times, because sometimes it can take a long time for that distribution. So at some point we have to say that there needs to be a mandatory arbitration so that there's no possible appeal except in an extraordinary fashion. How is it done? We have to do it based on giving prestige to the entities that provide these services, and for them to provide them adequately. We have the feeling on some occasions that when we go to the consumer arbitration, when we are facing entities that are public law entities, well, those arbiters, they don't have, they're not particularly well known for being impartial. So there's lots of things.
That's why I said that the response was complex and dependent on many things. I have the microphone back, but we've known each other for 20 years, and you know I've always contradicted you in many things. Don't act as a lawyer. I mean, this reading is not good enough for me. I wouldn't go for mediation. You would just get more for it. You would earn more if you were to be a lawyer. This is how things are, Pascual. And I'm saying this only because I'm fond of you. Well, you need to increase the fees of lawyers. Then we can also speak about arbitration courts, private arbitration courts, and what they make and earn. I mean, this is not a public system, is it? Consumer arbitration, I mean. But allow me to say one thing. I do admire everything that you've been doing as a master of mediation. You know that we worked together when you were working on the Catalan mediation, and I am not going to turn this into controversy between you and I. We haven't heard from Paloma yet. But I do invite you to come to a consumer arbitration. Just come down from what you've read on books. And I'm saying this because I'm fond of you, and there's many companies who are really happy to be inside or working on this. I have some friends here in the hall, and I've told them I don't want for lawyers in the banking area I don't want them to stop making money, but they need to do it by doing compliance and showing how contracting is done. And this is what you were saying before, having a robot. We can talk about the draft bill that will guarantee personal assistance and attention, not from robots, but from humans. In some occasions, it was just to warm things up a bit. You're younger than me, and I am a historical optimistic person, but I start being pessimistic now. Well, things are not going to change. It's just a couple of years different. Okay, Paloma, I believe that we do have particular fortune here out of the 3 speakers participating in this round table. She is working as a professional in the courts, not just as a professional, but I live very close by. And secondly, also, she holds a relevant role, allow me to say, as I did my criticism towards Pascual, and I asked him and invited him to come and see how an arbitration system works. But she does have a fundamental role in this sense. So I'll take the basis of what has been said, but mainly about the relevance of collective interest and public interest in these topics. Thank you. Well, if you will allow me just 1 minute, because I'm really here because Marilo invited me, Isidoro as well, of course, but the invitation came from Marilo. Marilo was a person I had a huge friendship with for a very long time. So she encouraged me to come into consumption, and I do professionally admire her a lot. Despite this is a very tough day for many of us being here when we were just bidding her farewell yesterday, it was important for me to be here because 10 days ago, apologies, I was with her. She was willing to come here until 15 days ago with her oxygen pump because she wanted to come. Then she saw it was quite impossible. She was admitted to hospital and she couldn't really come. And when I saw her, she said, Paloma, you must go because we need to speak. I am going to become a defender of all this today. We need to speak about arbitration and the progress that has been made in mandatory arbitration. This is something I don't know a lot about, but, well, I'm still brave and courageous. And despite what the magistrates or professors are saying, they're retired, Paloma, don't worry. Well, I'll speak in favor of arbitration. And I'm saying that I'm in favor of arbitration because I know the day-to-day justice and legal system quite well. I used to be in criminal court and now in civil court. And when we speak about effectiveness and consumer protection, I have noticed there's some sensitivity by judges, particularly new generations of judges. I'm not included in those, obviously, to attend to this consumer protection and for their rulings to be favorable mostly to the interests of the consumer. Judges and prosecutors are more and more committed to consumer protection, and proof of this is the creation of consumption prosecutors' office. You know that there's great confidence in the criminal side of things, but in the civil side of things, we have a lot to learn. So we're there trying to make this work. If we speak about effectiveness, Article 51 in the Spanish Constitution, the mandate is clear. Not only do we need to protect users and consumers, but we need to do this effectively. And here I believe that the City of Justice is not doing a great job. It's really hard. The provincial court, when doing the dossier the other day, he mentioned that in 4 days there's been double the amount of appeals to 22,000 in the year 2024. And he spoke about the need of creating up to 36 first instance courts in the province, and this represents a huge lack of means. So in practice, when we have a claim in a court of Barcelona by a consumer, they'll have a first instance waiting list of 2 years and then 3 more years to the second instance. We are on an average of 5 years to solve disputes of a claim for some, I don't know, some suitcases that have been lost. So with these times of action, we cannot speak of effectiveness in consumer protection. And as Javier was stressing before, lawmakers have created some procedures, yes, but I still have to see some witness disputes, but there's many hindrances that have been included more than elements in favor. And in truth, and here I will criticize lawyers a bit, is that despite the importance of collective actions, and apologies, I'm looking your way all the time, but that's why I got the idea. They don't look for global solutions. They're really interested in the individual fees, and with these means, it's really hard to achieve effective responses. And if we go into collective actions, which no doubt is a fabulous tool to manage speed up of justice and a practical solution to real problems that we're seeing day after day, we have no effective regulation or practical regulation. And let's only remember, how does the sentence go? Disputes you would have if you, and may you win them. It is basically saying that it's done for the execution of collective actions, because we have found that the prosecutor in other provinces has had collective actions, and I remember the first one in Córdoba that was awarded in a cautionary amount of time for justice, and there was 114,000 damaged people, and thanks to the law 510 19, the prosecutor will push forward the execution of, well, truly the feeling is quite of concern. So we're lacking means, we're lacking regulation, and we are lacking specialization, and that's what we're working on. Okay, I had some questions for you, but I'm terrible at this. I don't like them. I believe that there's some topics that have come out that I do want to go back to. Let's start from the very beginning, and I'm going to be very daring here. But why are we talking about justice here? To what extent, in terms of conflict resolution measures, to what extent mediation, the consumer arbitration mechanism, is not considered as a solution to the problems of the consumers, but rather a path to bring out of courts of justice all these claims? This is a question for all of you. So what is the role of Consumer Prosecutor's Office in these cases? Because this is something that you wanted to answer, I know. Sometimes we do complain, those of us who are responsible for letting people know more about arbitration, so perhaps Consumer Prosecutor's Office is not well known. But my question is, do we believe there's another alternative system that can solve disputes, or are we only using it because, justice takes a long time? I come from the criminal law side of things, and conformities before trial is the great paradigm, and we believe they're super useful. Conformity, well, we know that in criminal cases, the best is better than the best ruling, and same thing happens in the civil itinerary or civil law. In fact, Organic Law 125 does stress friendly resolution of conflicts, and that's the benefit that we will get. But I believe that citizens, or what we must do, is awareness-raising campaigns so that citizens know that they have these mechanisms in order to access arbitration. We need to invest much more. In fact, this week I heard some commercials or some ads on the radio, very discreet ones, by the way, on arbitration. I was thinking about arbitration institutions, and I thought much more money should be invested to make this well known, but much more money, more than injustice even. Allow me to ask a question to any of the three of you. How much is a verbal trial? Well, I don't know how much lawyers make. I don't know. No, I mean to the citizen who pays with their taxes. So, how much is a verbal trial?
Bueno, al departamento.
An oral trial? The Department of Justice, well, I know I have a witness there, and he tried to learn 20 years ago. 500 euros, that's what it was 20 years ago. You can update that. I don't think price consumer index is going down, so it's probably around 800 now. So how much is it to go to consumer arbitration for a minor dispute of less than 2,000 euros? I'm not going to ask arbitrators what they're making. I'm not selling encyclopedias, just telling people to become arbitrators. Well, it is a huge world of difference, I will tell you now. It's much, much less than that. So how long does justice take to arrive to a resolution? Well, there's the oral one, and if they can charge for the appeal, now depending on the figure, you can't go for an appeal. Well, what do I always do? I have it here on my phone. We all know Article 24 of the Constitution, don't we? Come on. Just everyone has a right to obtain effective judicial tutelage of courts in the exercise of their legitimate rights, and in no case should there be exercise in its own defense. And what about Article 51? Article 51. Those of you who studied it recently, well, after the fundamental rights, well, Article 51 of our Constitution establishes as follows: the public powers will guarantee the defense of consumers and users, protecting through effective procedures, not establishing they should be legal, the security, safety, and legitimate economic interests thereof. We stayed back with Article 24 and then 25 onwards. It's just basically for the future. I mean, this is a true challenge for us all, isn't it? What should we do? There's one thing Javier said I really liked. I was all comfortable here just listening. Well, Marta Rovira, she's here, vice director of the agency. For a long time, we've been assisting the agency and asking, how come we don't have a database of the arbitration awards so that everyone can disseminate it and study it? But honestly, there's something I can say here. I don't know whether we have someone who represents some of the companies in this field that you just call and everything gets solved over the phone, these telecom fields. So the most relevant companies in Catalonia were subjected to arbitration voluntarily some time ago, and there's been a drop in claims of 30%. What have they done? Well, besides from these awards, that, well, there's no appeal there, they have taken on as best practice criteria in their day-to-day work in the companies that, well, what arbitration awards are establishing. Consumers will not only be better and will have better solutions to their problems, faster, quicker, less waiting times, but businesses will be able to compete better in the markets because customers will be much more loyal knowing that they will find a solution for them. Yes. Well, I want to have or to hear from the audience later. Yes, we can hear you. Javier, we can hear you. At the beginning, I said that in terms of effectiveness and based on what you're saying here and many more figures we could deliver, we could not doubt that the arbitration system, along these lines, it is not only complementary, but it should make further progress because costs are much lower, it's quicker, faster. It is true that I would defend to have, well, so that it can overcome the level of the accessory appeal or lesser appeal, which is how it's sold sometimes, and at least to have it at the same plane, professionally speaking and independently speaking. Also, that's what I was saying before. It is very important for us to have a doctrine of, well, that is doctrine basically, that provides legal certainty, and we can actually work on that. We can work on it, we can speak about it, but we speak about certain things already. So we should truly promote that. This need to connect it to companies, that's essential because business people also need to own this arbitration system. They need to trust the system. So they need to trust in this reason of independence and professionalism, which will give you a guarantee to trust the field and the system, so that they also need to participate from it as well. That's a guarantee of the very same thing. And along these lines, everything that means going deeper will be good. I do agree with Paloma because, well, in the first magistrates, that civil law magistrate was basically, he lived in a different world. Jose Maria, I remember him. And sometimes he came along, he visited us, and yeah, we take note of this, of that. But as I was saying, this witness dispute could be even a mute witness because, in my opinion, this would be a totally different conference. Collective action falls short of the practical and real life. Of course, it is obvious that lots of progress is needed, a lot of culture. And in terms of effectiveness, I do see the arbitration system as a system with a very clear progression. The arbitration system can also participate in other mechanisms that are also abundant, as Isidor was saying, in, well, making work easier because that work is already done by companies. The publishing company Planeta already has a transparency protocol here in Barcelona. Yes, I know of it. Yes. It could be improvable, of course, but they already have one. So we will need to tell companies that those protocols and the way they have in participating for a better understanding, this is something basic for them, which is contracting. That's a truly interesting starting point as well. And everything that works along those lines will obviously improve the effectiveness of consumer rights. And therefore, there's lots of things that can be done. The mediation system, for instance, as well. It is a great unknown. When you speak with people in mediation, they tell you, well, people speak a lot about mediation, but they know nothing about the method. It has its own method. But we are in a turning point, basically, and there's no going back because the legal system cannot absorb and provide a response. I mean, we cannot transform there because it would not be a realistic response. And even more, I believe that the legal system, Article 51, I do know it by heart, but I didn't say anything. But we have some younger people here. Anyway, people said, well, do you want something that's programmatic? Then here you go. We will see. And we should not have effective levels at the same level, which are different to Article 24, which effectively is in the courts of justice because they are the only ones who can truly be independent. Yes, but I was just, provoking, basically, being controversial.
Progresistas o crédulos o incrédulos, pero igual los crédulos dicen.
I don't know whether you're progressist or conservative. Well, this is just a principle of inclusion, a basic one, yes, but effectively Article 24 has that touch point and that how it should be in a democratic society subject to legality process. And one thing is administrative controversy, the facilitating one, and the other one is Court of Appeal. We always need to have that. But them on their own, they will never be capable. And after all my experience in the first magistrate court, I don't think every case needs to reach the Supreme Court. And we used to have lots of discussions over this. When we were at our first stage, when I came in, when I arrived, well, back in 2011, 2012, we had 5,000 pending cases, more or less. And Juan Antonio was horrified and he wanted to carry out a sort of mechanism to get updated in 4 or 5 years. Do you know how many pending cases there are now? It's not because I left. It's not just because of that. I wasn't part of the hard-working team, but there's 20,000 now. 20,000. So if we think that claims of cassation will be fast, we know that's not going to be the case. You either speed up procedures and regulations, or you have more magistrates. But they're still the same. 10 magistrates. There's no 20 nor 50. So that's not realistic at all. Or what I'm telling you, not all matters. Well, the North American, the U.S. Federal Supreme Court, there's only 80 cases attended every year. But these 80 cases are, in a way, have a legal, social, and economic transcendence and importance of very high levels. So here we saw cassational interest, horizontal property cases, as you were saying. And people who like this, that's all fine and well. Because in the end of the day, no one knew about servitude. But, we were wondering, why cannot we solve this? I believe that those benefited from this all are courts themselves, because there were many matters that, because of their amount, because of their complexity, they need to have a more suitable itinerary to be solved well for guarantees, because in the end, you will always have the possibility of, unless you have a binding procedure. I won't open up a discussion of the extent. I gave you an example of a dispute that cannot be appealed up to I don't know how much money. So I spoke about perhaps not going to the Constitutional Court with an early recourse or appeal. But Paloma, I tried very dearly to get you to talk about your book, Remembering Paco Umbral, and what is the role a prosecutor's office could have in terms of effectiveness and efficiency. Yes, I do believe it can have a role. The Consumer Prosecutor's Office is the great unknown. Nobody knows what a prosecutor is doing in consumption. There's quite surprised faces here. But prosecutors have very relevant roles in consumption, and it also has we know social interest, we know this, and also the Constitution states this in Article 24, but the prosecutor has an even more important role, I believe, that sets them aside. They need to promote the action of justice in defense of the social law and social right, as well as interest. So the prosecutor has advantages to promote because they have legitimacy to exercise individual actions and collective actions, which is a legitimacy field that any other legal operator cannot have as readily available as the prosecutor. They have territorial application throughout Spain, so if something extends to the province of Barcelona, it could also be applicable to the Supreme Court, and they can get, it's cross-cutting, so we're not only specialized in civil law, but also administrative, contentious, criminal, we have financial offenses, so whenever something is not against a company, but rather against the administration or in litigations, we can also act and refer those cases to other fields. And this easiness to intervene is limited by the social interest, so that we can intervene in individual cases as long as there is an interest in need of protection, a vulnerable person because of an objective or subjective reason, because it's an of age, a person of age or a minor or at risk of some kind, or even because it affects a group of people, so we can have collective actions defending the social interest. Where am I going to? We need information. We need information to intervene, and a source of information that is very relevant is the administration. I always tell Isidor, this touch point with the Catalan government is fundamental because they know how society is doing, where it's heading, where is the latest idea to scam the consumer. The Catalan government is always ahead of this knowledge. We get the claims when there's been a lot of suffering already, and we cannot have the global view. And arbitration at this point is very important because you normally attend to individual claims, but there comes a time when that individual nature transcends what's collective, because there is a common pattern, there is a clause that is being used by all gas companies that is setting a limitation to consumer rights that claim once and twice and three times. And therefore, when the administration cannot be effective, either because they cannot act, or because the punishment is not enough, or because the ruling is not enough, or the criminal case is better than the civil case because there's fraud or abuse of some kind that entails an offense, then that's when Consumer Prosecutor's Office can intervene, either individually or collectively, whenever possible, but always with the information that we get from society, and particularly from the Catalan government, and also arbitration. And this is what I came here to tell. A question as a student who doesn't know what this is about. So in the civil environment, to what extent can we preventively act? Because I know about criminal law, but, well, these clauses you just referred, it's very complex. It's very complex because they've been judges, both of them, if I'm not mistaken, and they will know that cautionary measures in civil law are very complex to set forth and to be awarded the ruling. Well, and a vulnerable person, which is the typology of cases you normally intervene as, the public general interest that is clearest is that vulnerable person. So despite this, do you not have instruments? Because, I mean, we have our sanctioning files, and we are taking notes of everything that will be sent to the Consumer Prosecutor's Office. Well, there's something else I needed to add. The Consumer Prosecutor's Office. Well, don't say that. Just say my team. Well, whenever there's a problem, I know I'll have a team. So whenever there's work to be done, I know that I have a team behind me. And yes, flexibility, whatever I take from here, I can put on there. But cautionary measures, that's no easy thing. You can request it, of course, and in terms of collective clauses that affect general interests is very complicated. But in order to do that, and I'm going, can you give us an example so that we can see it very clearly? The Consumption Ministry has sanctioned some air companies, but not because of imposing a fee on hand baggage, but also because some clauses that were requesting or demanding to pay the same amount for the ticket if we had a tutor, father or mother of the minor, that they paid a price, and some other clauses as well. I'm speaking about clauses and sanctions that were imposed. I know that there's the judicial guarantee, and one of the companies I'm not fond of because I never fly with it, they presented the corresponding appeal, and all this has been suspended. I know that there could be irreparable prejudices, but I studied law in Spanish. Sorry that I keep shifting languages, but sometimes we only are able to guarantee certain things. Yes, I totally agree.
These things that we're saying, there is a general registry of conditions and, well, let's see. We have 15 minutes left. It's important because we have talked about these measures, but when we talk about regulatory recognition, there are small matters of a regulatory nature, and it means that the same recognition will have less efficacy. Therefore, of course, this is important. It's important for companies, enterprises, to not have abusive clauses or anything similar to that. So this forces you to say, all right, you talked about the Praetor-Enter, and it used to be published, and anyone that did anything different from that edict, they knew that they had problems. And so I think that there are lots of things that can be done, but we have to make decisions in order to update everything that we're discussing here, to put all of this in value, and there is a transformation. Yes, the transformation begins precisely with seeing the regulatory structure and seeing what this regulatory structure needs or requires from an organizational point of view. And here we would be conservative in the sense of conserving the efficacy of this, and we would be progressive in the sense of getting a greater application of the regulation. So I believe that what we need to do here, what we have to demand, because often we have those of you that are in the administration, we have to say, okay, here we're doing something that needs the support, that has to be disseminated, etc. And the citizens, of course, well, if someone considers it reasonable to spend 12, 13, 14, 15 years to get a verdict, a ruling, maybe they can leave it for their children or their grandchildren. I mean, this is a court case that you're going to win, so I'm leaving it to you as an inheritance. So that's why allow me to interrupt. We have a little bit over 10 minutes. I'm optimistic. I suggested at the start that if anyone had a question, and I hope that someone does, I would like for the audience to participate and to establish a dialogue. Hello, good morning. I believe in the arbitration and consumer affairs, and what I want to put forward, and I think it's very important that we convey this trust to the citizens. And Isidro has been in the Association of Lawyers for many years, and I think they have to have an important role in this, the lawyers, the association lawyers, because sometimes if they go to arbitration, they make less money and they have fewer contracts. So I think that the Association of Lawyers in general, and those of you that have a certain public relevance for making agreements, well, we need the lawyers to believe this, and in the clauses and the contracts they have with suppliers, with companies, etc., they should add a clause that would send them to a arbitration court, because obviously our courts have lots of work, but if there are more cases, then the perception of the public will depend on how we frame it. Okay, let's see. Well, two considerations. My team will kill me because they know that I have these agreements with sectors, usually among the companies, to promote not only mediation and consumption, but also arbitration. One of the things that we have underway, at least I do, and we have some agreements with professional associations, even though not with the lawyers, but there are lots of these professional associations. I think there are 139 of them. And what I want is for them to get into a framework agreement and for them also to be inside of these consumption arbitration courts. Because I think that the arbitration system has another important thing that we have highlighted. These are not just some people that are coming from heaven, that have fallen from heaven like a god, that are going to solve your problems, but rather they are public servants. They are people, professionals from the sectors that claim affects. People from the area of the Association of Consumers, and they are somehow building the participation. So I understand your proposal. It's a proposal that perhaps goes further, but there are certain things that not everything should be included in the deontology. If we can talk about what deontology, because we're having claims against lawyers at the agency. I mean, it's inevitable. Anyone that's a professional or an entrepreneur or a business person, well, we haven't been capable, at least so far, even though we're trying, to make the solution more participatory here or wherever.
Bé, és pura i simplement dues coses.
I'd like to say two things. The director has spoken Article 51 of efficiency, and the magistrate has spoken of statistics. I would like to give you an example that I've experienced here in this place. In 2013, when the preferences for arbitration, the agency received more than 40,000 claims, 40,000 complaints. And the agency resolved these in 2.5 years. The second topic is that we've spoken of consumers and SMEs and we've spoken of them as consumers, but the consumption code of Catalonia protects the autonomous, self-employed workers. And finally, it is to I am an arbiter from in the city of Terrassa in our consumption arbitration system, and 90% of the claims have been solved with conciliatory awards. Well, to answer to the comments that you've made, thank you for your comment in the area of preference. The total number was 420,000 awards given as a result of the crisis caused by the preferent mortgages. More questions?
Sí, hola. Al fons, aquí al fons. Isidor.
One question that is really, I'm just thinking out loud. Do you think that the problem with lawyers is that great? And talking about, when we're talking about a process that could last from 2 to 5 years, and we're talking about processes where the amounts are less than 2 or 3 million, something that an amount that came up earlier. Is it possible to find lawyers that want to handle cases for these small amounts, risking such a long delay? The problem of the pedagogy that we referred to before, do we really have to introduce with the legal agents in the culture of the agreement and what has begun precisely this year? Is this something that we should promote? And on the other hand, the new systems and new technologies speak of an immediacy that didn't exist before. So I don't know to what point the lawyer, it's easy to find a lawyer that in issues of consumption will want to just be bogged down for 5 years for such a low income, for low fees. Thank you. Well, you have told me everything you know and more. I could also answer because I worked in that area for 10 years. But one thing, I think that today's presentation from Daniel Inerarity, well, what's very clear for me is that there's much to do at the lower level, in the schools, and at every age. Most likely this culture that you're referring to, and that for different reasons many of us believe, or we didn't know, but now we recognize that that should be the basis of arbitration and consumption, many other things. We have to work from the grassroots level. We have a problem. We have a law that was passed last year, an organic law of the regulation of the right to defense that came into effect in December of 2024 that said that the consumer has the right to know what the professional intervention of that lawyer is going to cost him or her, and what repercussion there may be of the costs that are paid, not only of the lawyer, but also of the other side in the case of losing. So what has happened? Well, a year has gone by. Why hasn't it been approved? Well, because there's a conflict among the lawyers and because the law of competition, a fair competition, it says the associations, professional associations, cannot establish these quantified amounts. So I don't really care, to be honest, because I think as a consumer I have the right to know that. But what's the saddest thing? That in 2010, the consumption code already says it. Any professional has to establish the criteria. And some of us that are here in this auditorium, at a certain moment, we tried to talk about consumption in the association of lawyers to say that things had changed and the way it was approached was not ideal. Cristina Vallejo from the school, from the well, I'm one of the older ones, and we have seen. I've seen her several times, and since things can be resolved more efficiently with lots of noise, we're seeing how to open the path, how to make a way. What is happening? Well, we have people that are coming to replace, to claim, to give us complaints of things, and it's said in the law. So why isn't it applied? Well, because the associations don't let them do it. There is an association in Manzanares in the Madrid area, and they made a consultation to the Council of the State, and it's not saying that it's the Spanish law system, but no, they said it to the associations. All right, well then let's sit down. That's one point. The Catalan Consumption Agency has established an agreement, which is quite interesting in my opinion. That is the Catalan Agency for Competition, and I can tell you that much.
Més preguntes.
More questions.
Micro, Carme. M'agrada perquè així passarem de l'hora, va.
I like this because that way we'll go over our time. Well, I'm going to be very quickly. No, I didn't say it for you. As a consumer, because you know that we represent the consumers. You have spoken of the ruling of the APC law. Well, it has been mentioned. Yes, he did. My question is, this claim, can it be done through the Agency for Consumption? This is a difficult or an easy question. Why? Because it's from many years ago, it's complicated, it's against the banks. But of course, to do this, you have to go to a lawyer, and it turns out that it's very complicated. Paloma Pellegrin, the public prosecutor for consumption, well, for there to be a lawyer that can take part for 1,500 euros and fight for several years to see if the bank returns that or not. Could this be included in the Council for Consumption? Let me begin with the easy part. There are people that have created companies to present claims. And we asked how these things are financed, but some said that they paid the people that they had working there without following regulations. So everyone has their ethical limitations, but some of them have very diffuse values. But I will not go against my profession, and much less against the lawyers in the area of consumption, and I can give you many examples. I can point it out, and I can count on two hands the cases, but I know, as far as I know, here we have a true master in this topic, many of the rulings, because after all, it's the Court of Justice that have given him the that has ruled in his favor. But we've been working on this, and we haven't read the last two rulings. After everything that I've heard, I don't even want to read them. Some lawyer colleagues that were very involved came to the agency at a certain moment, and called me, not yesterday, but rather Thursday or Friday, said, let me see where we are. And the agency didn't take legal action. It doesn't. I hadn't considered that possibility, but I don't want to even imagine the technical problem and the report. I'm not saying no, but first we have to see, and it has to be me who takes on the title of this ruling. But in here in Catalonia, the Association of Lawyers, I participated together with two of my colleagues in the regulatory proposal to put forward a bill for reforming the income tax, the personal income tax. And a law might take a year and a half to get to the end of a court of justice with all of this issue. We told a minister, it's not the current minister, nor the previous one, nor the previous one to that, and the solution was, well, simply to get to an article, since well, if we talk about the withholding tax, if it were just one, the personal income tax, but perhaps the solution is here. The current ministry is aware of this. But didn't you go years ago? Yes, but the Association of Lawyers of Barcelona, they were very stubborn, and we need to recognize their ability to insist, and they continued putting this forward to each of the ministry teams, including this one. And it's very clear in my mind because it was my introduction to the General Director on Consumption of the ministry, Isidor. Jesus Sanchez said, call them, tell them that you this, that you that. I said, well, wait a sec. We have to sit down and talk about this. Perhaps the coffee has, cooled off. I'll have to put it in the microwave to warm it, heat it up again. More questions.
Ah, perdona, no, Pascual, di algo, por Dios.
Bueno,
Bueno, si no...
Ahora sí. Bueno, quería comentar.
I wanted to ask one thing along these lines, having to do with the role of the lawyers. The role of the lawyers, we have to keep in mind that the associations of lawyers, unfortunately, despite their characteristic of being a public institution that defends the citizens, etc., but they are nothing more than a union, really, and they're unions. And when it comes time to establish any kind of a limitation to collective groups, because there are lots of types of lawyers. There are people that want to make a living decently with law, but when we have elections, the important thing are the votes. So to what point is that taken into account? I think that if we look at comparative law, how have we been able to make it so that the lawyers themselves keep in mind another type of action which is different from that of going after a victory in order to earn their fees? There are two terms that have struck me. One is the inappropriate litigation. Inappropriate litigation. So, in the case of the courts in North America that have adopted the criteria of the multi-door from Sanders, is to establish filters in that before it was done in the courtroom. This has to do with the access to availability of justice, and because access to justice means that justice should be served, but you cannot, justice is not served if it takes so many years. So it's an initial filter so that inappropriate, the litigiousness, well, because the criteria are established, etc., and this filter is used. And the other clear filter is the one that we have. The legislator has made a mistake in some cases, and I believe that
I'm trying to find it.
the reform included the costs, the fees, through the flexibilization of the principle of the costs of the fees that subjected both the courts as well as the principle. I think that the message of the law is that there's going to be a flexibility in the costs, and if it's not reasonable in the legal actions taken, then those costs, even if you win the trial, they're not going to be paid. Because it was very clear with that, the jurisprudence, etc., and these are issues that are not specifically for a judicial or legal debate. That's very important. Here, the legislator has made a mistake in this sense because they have put the principle of admissibility, and in many sectors of lawyers, they have skipped the stop sign and stop light, and they are fixed on the idea that they have to reach the trial, get to the judge, rather than helping the citizens, their own clients, their own customers, to resolve things through dialogue, and that is what the law establishes. Thank you, Pascual. Well, they'll call you because you know that's going to change. At least there was a vote on this in Parliament. Only 2 votes against. The parliamentary groups that support the government, you see how I've said that there? They abstained. And the only thing that I'm asking for, and my people know this, unfortunately, this type of epidemic that Spain has, that is the pendulum. Now we're going to go to the other extreme, and those of us that weren't involved in this, well, we may end up being affected by this. And this is the last question we have to finish. One thing. Wait, there's a question, but it's I think that the income tax, the personal income tax, we have to take into account that what we heard from the court were parameters to give some orientation. For me, the binding indications are the ones that come from the Court of Justice, and what they use as a references that are specific, because in both they mention a circular 5/2024, but what happens with the other ones that were not mentioned? So not much can be done to save these, in my opinion. Thank you, Javier. Okay. We have a good friend participating tomorrow from a banking institution. He's one of the lawyers of a banking institution, and we can talk about mediation and consumption. There was a question.
Sí, bueno, bon dia. Soc el responsable d'una...
Good morning. I am responsible for an office, and I found very appropriate what Mr. Ortuño said of the fear that some lawyers have to subject themselves to an arbitration, because if they lose in the end, the client can, demand damages, and there's this fear is different than the fear that the associations of lawyers have of getting their fees. And Mr. Tuño, as well as the rest of the panel, the question is what mechanisms are put at the service of lawyers or at the service of this situation to overcome this fear of lawyers of not undertaking an arbitration because they are afraid of their clients suing them at the end for not having gone to a court. Well, you've talked about unions. I never would have said that, so you answer. Well, let's see. We have to talk about what it is. It's difficult. It's difficult. I think that arbitration has to have a certain prestige of the arbitration system. It has to have a prestige, and that must be gained so that the citizens will go to arbitration because there are a series of advantages, speed and fairness, etc. But unfortunately, that has not been achieved for quite some time. The number, the statistics of the arbitration courts, there are many of them. Only in Catalonia, I think there's 7 or 8 that are world arbitration courts. But when you go to see the statistics of the arbitration, you see that there are very few. And that is the issue at hand. These arbitration councils are successful if they have a reputation, like the one in Paris, the one in Geneva. So we have to work on this. And unfortunately today, currently, we don't have that. Well, I'll just take the floor to close our panel because has anyone told me that? I've been told that we've come to the end and you want to ask something? Okay, well then I'll give it to you.
Okay, no trouble.
Sí, se sent bé, sí. Bé,
Can you hear me? Yes, well, firstly, it is unavoidable to open up different parallel discussions, of course, but just to close, because we're tight on time, but it would be good to focus on the main question for this panel. And as Deputy Director of Consumer Service here, I would like to say that sometimes we oversimplify discourses, but here we're referring to many people who will never go to legal proceedings for just a basic service claim and will never have an effective response in through their legal proceedings, and I believe this was not properly answered. And one of the main elements that is always referred to when we think about mandatory arbitration to claims of an amount below 2,000 euros is this effective tutelage requirement. There's the document, as the director said, that was drafted by our beloved Marilo, and precisely to save this gap was basically to have a legal body to review the award, and I believe these two elements should be taken into account. We no longer have time now, but perhaps we can deal with them the rest of today or tomorrow, because these are the main limitations that we find in our day-to-day. So, any final contribution? Final? I mean final. Hello, I am arbitrator in the Balearic Islands region, and going back to the topic of effectiveness, I would like to speak about a case that I had as a civil servant. There was a lady who came along to the office. She was very concerned because she received a letter from a power company, and she'd been taken 2,000 euros had been taken from her bank account, and she had not received bills for a certain amount of time. So she was told that she would be without light in the following week. So what could we do here? Well, luckily with this power company, we have direct contact with some of the managers or people there, and we told her this is a very common problem, unfortunately. And I sent an email to the person we have as a contact person in this company, and I said, please stop this power cuts process because this person is going to start an arbitration procedure. I gave her the details, the information, and she said everything was under control. I told the claimant, and that was effective. If that person had to go to court, she would have to request a precautionary measure, then request or place a lawsuit, and that was just a 20-minute case, and that person got back home. And I also was able to act as a proper professional, and well, that person had lights and power during the weekend. That is just one case. We've had many similar cases, and it's something that is so simple that we don't need to make it more complicated at court when it's just, an arrangement that can be done in 20 minutes. So companies should trust us, and we should have direct contact with territorial managers in those companies because this makes our lives easier and our works as well. Thank you. And I would just close this session now because we're out of time. Thank you for all your contributions, for all the questions as well. And I've taken some notes of the most relevant and interesting ideas on how to try and improve. I believe that, well, honestly, the answer to the question we already knew before coming here. But this has been great to bring along some more ideas of our system, knowledge of our arbitration system, and also teaching and training from down below, involvement and engagement of the different stakeholders. And well, we're not going to draw any final conclusions now, but well, there's a new session, a new round table next. I'm not sure if they have such a definitive starting question, but it's quite more simple. It's about the present and the future of consumer dispute resolution in Europe, because some of the people here with me in this session, well, we're not out of Europe. There's many milestones that Europe has set in consumption, and we're so proud we have them here, and we're so proud we've been able to apply them, and for sure, many more to come. So thank you, everyone.
Bé, doncs, sens dubte.
So, no doubt this first roundtable has been a super interesting one. Thank you to all participants, the moderator as well, all the different participants who are basically enriching these discussions that are truly effective. It is a complex topic, but there's many subtopics that have risen that will be dealt with today and tomorrow. We have 3 roundtables tomorrow, and we will bring out all these topics again. So thank you for your attention and thank you for your participation. So yes, you can take a seat, and now we will start our second roundtable, which, as Mr. Garcia was saying, is devoted to consumer dispute resolution in Europe. We will now be changing the title now, moderated by Ms. Rosa Jimeno. He's at the technical head of the Catalan Agency of Consumer Affairs, and I'll tell you who will be participating in this roundtable. For starters, I will introduce Laura Ballarín Cereza, one of the participants. She's a member of the Progressive Alliance of Socialists and Democrats in the European Parliament, and I must say that because of calendar and agenda limitations, she will connect online. So we will start hearing other participants in the table: Fernando Viana, Director of SIAB Consumer Arbitration Tribunal or Court of Braga in Portugal. We have him here today. And Aida Gasiunaite Stavichinskiene. Apologies, very difficult to pronounce, but we also have her here to contribute to this roundtable. And unfortunately, we have to apologize on behalf of Ilaria Amelia Gaggiano, full professor in private law at Suor Ursula Benincasa University in Naples, Italy. For a force majeure problem issue, she will not be able to connect. So she is excused, and just for you to know. So we will get started with this roundtable. So consumer dispute resolution in Europe, present and future. Rosa, you have the floor. Thank you very much, Elisenda. Can you hear me all right? Yes. Good morning, everyone. Thank you very much for coming, for being here, and for making some space and room in such a day. With so many things to be said and so much passion to express them, we'll do our best. I wanted to say hello and thank the presence of my colleagues. Fernando Viana is very well known here at the Catalan Agency of Consumer Affairs. He's a role model in arbitration, in mandatory arbitration and mandatory participation of companies in consumer arbitration in our neighboring country, in Portugal. He holds a degree of law by the School of Law of Lisbon. He has a postgraduate course on contractual law by the School of Law in Coimbra, and also a master's on law and information technologies by the Dominio University. He's conflict mediator, and Fernando also acts as director of SIAB, which is the Consumer Arbitration Courts of Braga, and the National Courts of Consumption in Portugal, and he coordinates procedural activities at FINAC, the National Consumption or Consumer Court. So, my dear friend Fernando, I would like to ask you, could you give us a summary or a bird's eye view of the main characteristics of the consumer dispute resolution system in Europe, ADR, and how it works in Portugal, mentioning some things regarding competencies, whether they have any specific characteristics, whether it's for free or financially accessible, what type of nature the entity has, or these courts, or these SIABs, whether they're public or private, or a mixed, of a combined sort. A rough figure of the volumes. We will hear later on some figures as well, and we will make them available to all. And could you also explain what are the Portuguese authorities in charge of assessing and controlling the ADR consumer systems in Portugal? So, Fernando, you have the floor.
Sí, pot agafar.
Yes, you can use the microphone, please.
Sí, yes.
Well, now begins my war with English. I'm sorry for that. Firstly, I would like to thank Agência Catalana de Consumo for inviting me to speak at this important conference, which is an honor for me. Special thanks to Rosa, with whom we have established a regular working relationship over several years, and who has shown great interest in learning about the Portuguese system of alternative dispute resolution for consumer conflicts. Indeed, I believe that the Portuguese consumer arbitration network is a powerful means of empowering consumers, but it is also very important for business because it helps to promote the supply of quality goods and services, and in the event of a complaint, to provide a quality after-sales service. The Portuguese system is based on a consumer arbitration network comprising 7 consumer courts on the mainland and 2 in the autonomous regions of Madeira and Azores, which have the following essential characteristics. With one exception, these consumer courts are private, non-profit entities with members including municipalities, consumer associations, business associations, universities, and each one has a different regional competence and only in consumer conflicts. The law that transposed the ADR directive is its main legal basis for action, in addition to other laws such as the voluntary arbitration law or the mediation law. Therefore, the system uses mediation, conciliation, and arbitration as intuitive, simple, and easily accessible resolution procedures for the parties, organized in the form of multi-step resolution. It means if one procedure does not resolve the issue, the next one is used. One of the advantages is speed. In 2024, the average duration of each process was 57 days. Another advantage is proximity. For example, in one of the consumer courts of which I am director, we operate in a network with the 24 municipalities within its territorial jurisdiction. Another advantage is easy access for consumers, who can access the system in person or through an electronic platform where more than 80% of cases are filled today. The agreements and judgments obtained in those consumer courts have the same value as the state courts. It should be noted that in Portugal, those procedures are provided to the parties completely free of charge in most cases. However, the main advantage lies in compulsory arbitration. When ADR began in Portugal in 1989, the system was based on total voluntariness, meaning that when a consumer filed a complaint against a company in a consumer court, the company was free to accept or refuse, with the only exception for refusal being full adherence to consumer arbitration, which is residual. Our country implemented a consumer dispute resolution system based on consumer choice, first in 2011 for consumer disputes relating to essential public services, such as water or energy supply or electronic communications, and later in 2019 for consumer disputes of low economic value, up to 5,000 euros. If the consumer chooses the consumer arbitration network, the economic agent is bound by that choice and cannot refuse. This system has completely revolutionized consumer dispute resolution in our country, which has become extremely efficient. For example, in 2024, 9,216 cases were filed in the 7 consumer courts on the mainland. 9,381 cases were closed, and 7,869 cases were resolved. When I say resolved, I mean that They were closed by agreements in mediation or by conciliation or arbitration, which translates into a resolution rate of 84%. About 40% of these cases concern essential public services, which remain the most frequently complaints about consumer area in ADR today. The Portuguese ADR system is monitored and supervised by the Ministry of Justice and Ministry of Economy, and its funding is essentially public, shared between the states, essential public service regulatory authorities, and, in some cases, local authorities.
Moltes gràcies.
Thank you very much, Fernando. And I will ask the second question later because my colleagues in the room are telling me that Laura Ballarin is already online, so we can hear from her now. She is in between parliamentary sessions in the EU Parliament, so before we hear from our colleague from Lithuania, we would perhaps go to Laura Ballarin first. So whenever you wish, if we could please have her on screen. Good morning. Good morning. Thank you so much for attending our conference. Ms. Ballarin, I will introduce Laura Ballarin, holds a degree of political sciences in a specialization of European politics by the University of Kent and Pompeu Fabra University. She's been at the European Parliament since 2012 from the PCSC Socialist Party since 2023 and subscribed to the Progressive Alliance of Socialists and Democrats in the European Parliament and spokesperson of the Internal Market and Consumer Protection INCO Committee of the European Parliament. Good morning. Ms. Ballarin, Laura, thank you for your presentation. We know that you are going to other sessions now, so let's try to be brief regarding the objectives and goals of your presentation. 12 years have gone by since the passing of the consumer laws and directives in Europe, but back in 1989, the European Commission, in 1998, there were some recommendations speaking about objectiveness and partiality regarding ADR in consumption, and therefore we have some statistical data of Europe of 2023 saying that 25% of European consumers have problems in consumption, but 1/3 does not make any claim, and only 300,000 claims are solved through this extrajudicial system or alternative system. We all know that the reform of the ADR directive is focused on market evolution, on traditional consumer revolution vis-à-vis a more digital market, cross-border resolutions, and 2 years have been needed to carry out the test. And could you please explain the procedure, the main progress done, and are there any missed opportunities, or what would be the application scope of the norm or the modified directive? So you have the floor. Thank you very much. Can you hear me all right? Okay, thank you very much, Rosa. And firstly, thank you very much to the Catalan Agency of Consumer Affairs for inviting me to participate in this very important conference. I believe that you have a very high quality session, and you're doing a great task at consumer arbitration, but not just with that. As an agency, you are always following the European discussions and following the new consumer trends. So congratulations for all the work done, and apologies for not being there with you today physically in Barcelona in person, but I had to be here in Brussels. But thanks to these new technologies, I can participate online. I hope that the speakers from abroad do have translation. You're speaking Catalan, so I'm sure that they can understand me. That's been a very good introduction, and as you were saying, this proposal to modify or amend the 2013 amendment by the European Commission, which was presented back in 2023, 2 years ago now, in October 2023, had as a goal to try and update, on the one hand, these different mechanisms for the new digital reality we're facing, the new digital world, and the explosion of e-commerce that we are experiencing nowadays, that brings along some advantages, but also threats and risks for our consumers in Europe, but also trying, as you were saying, with these figures to try and increase the participation of consumers and companies in these alternative mechanisms, because, well, we are seeing that the figures are very low. The proposal was an ambitious one, as you know, of expanding the scope, reinforcing the different competencies of member states to reinforce cross-border cooperation, and also provide some incentives to consumers so as to have a greater follow-up of claims or traceability of claims and force a quicker response by companies. That was, in a nutshell, the proposal. So what we did, and well, I'm the speaker here, so just to mention this, we had some first reading negotiation, which was quite speedy, and there was consensus between the different political parties before we ended the most recent political debate, and we voted it back in March, so one of the last sessions that we had in the most recent mandate in the European Parliament. And basically what we did was to include some mentions to reinforce some of the parts, and we wanted essentially to include the mandatory participation of airlines in these mechanisms. We knew this was a very ambitious proposal, but we wanted to do it from Parliament to see whether we could actually reach negotiations with the Council. And on the other hand, we wanted to very much reinforce all our incentives for consumers and companies. So I'll go to negotiations so that you know how they went. You're all experts. So the Polish presidency, which was in charge of leading these three-side negotiations, as we call them here in Brussels. So when the term started, and this was all in the last month of the year. So at first, there was not much flexibility in our discussions with the presidency. And this struck us because we thought a review would not be problematic. Because, as I was saying, there was a quite easy project after the first reading, but a new parliament comes along. I don't know whether you're updated with European politics, but with this new term or mandate and a parliament that has turned more towards the right, we found it harder than expected. Also, the Council from the very beginning was not too flexible. So just to give you an example, in our second discussion, the Polish presidency didn't accept any of the things that we set forth, and we ended up reaching an agreement in the third and fourth meetings, which were the latest of the Polish presidency at the end of June. The main disagreement points were, without a doubt or without surprise, the first one is mandatory participation of airlines, as we were expecting, of course. We must say that some countries were in favor. We had absolute opposition, and well, Spain supported us, but countries such as Germany, because it struck me because their national law of ADR mechanisms does include airlines, and I participated in a conference with you, and there were some German representatives, and they gave me figures on how this was working, also in Austria. And these countries, for instance, blocked absolutely blocked the possibility of including this mandatory participation. Their argument was that this was just an obligation for a specific transportation field, in this case, air travel, and therefore there could be no inclusion of a horizontal review of this ADR for this field or sector, for this industry. So as a representative of Parliament, I tried to keep this alive up until the end and to try and see how it played along with other regulations, such as the Directive on Passengers, which, as you know, is still blocked, or has still been blocked for many years. It's a sensitive matter. And on the other hand, there were some topics such as the extension or expansion of material issues, contractual and pre-contractual issues as well. The Council was very much against this. The Commission was insisting upon this, specifically e-commerce, and extending this to contractual obligations and pre-contractual obligations. And nonetheless, this was a provision that was not too clear by Parliament. Then, geographically speaking, we got very much aligned with the European Commission to insist that those companies or traders out of the European Union with the sale of goods and services to European citizens could voluntarily participate, because we know that we're speaking about a voluntary mechanisms. And, well, so far, as you know, this was not allowed. And the Council was very much against this extension, mainly because it was afraid that big corporations and companies, I'm not going to mention them, but they're flooding the European market with e-commerce, and they were afraid that they could participate in these mechanisms to launder, basically, in a way of laundering methods. And anyway, they were not too flexible. And two further things, we wanted to reduce the response time, the days that traders have to answer back whether they want to participate or not in these mechanisms, just to provide security and traceability as well to consumers who are requesting this. And we went from 20 down to 15 with some exceptions. And we mainly wanted to have them respond very clearly. The Council wanted to maintain from 20 to 40 and to expand these periods as much as possible. And then finally, we could say that the Council was against new obligations for ADR mechanisms, those that cooperate with national authorities, or specific requirements whenever we find unlawful practices or the confidentiality principle, mainly for traders and retailers who had to provide in writing their obligations and some other obligations for member states. This is not surprising, because we wanted to have more guarantees by the European Parliament, but the Council did not want to have more obligations. So I'll tell you basically the conclusions. I'm sure that's what you're interested in. So the third discussion was on the 23rd of June, as I said. The latest in the Polish presidency was quite symbolic. And what was the conclusion? Well, in the end, there was agreement by member states of paying special attention to those fields, corporate fields with low level of participation and with a high level of customer claims. And these include transportation and tourism, particularly regarding the rights of airline passengers. And I'm giving it to you as it was agreed. There's no mandatory participation, but the Parliament insisted on having the rights of passengers, and these two fields, tourism and transport, where we know there's a great amount of claims by consumers, and where we believe that these ADR mechanisms can speed up processes that are blocked and that people feel frustrated about. And this is also something I mentioned in negotiations to avoid the expansion of private companies that are making a lot of money out of the mediation of these claims. They keep 50% of the amount if they manage to get compensation by companies. And with this argument, we managed to have a mention of these rights of passengers.
The member states can also introduce the mandatory participation. It's important to make that clear. But for me, it was a victory, and I would have liked to have seen mandatory participation. But the way the negotiations went, we can still say that was a step forward. As far as the material extension, well, it restricts the material area to what is included in the contract exclusively. We were not able to go beyond that as far as pre-contract and post-contractual agreements, and the Commission did not know how to explain these arguments very clearly. So this remains as it was. We haven't moved forward, but we were able to achieve at least to increase the geographical area for those that are outside of the European Union. So enterprises from outside of the European Union can also apply for ADR. And this litigation involves those companies from other countries only if it was not effective in their own jurisdiction, and so this can lead all of a sudden to causes open procedures in alternative dispute resolution with external countries, with companies like Shane or Demo, if they decide to participate in these mechanisms. So it will be taking place more progressively, and hopefully it will not overburden these entities, these entities. And finally, to respond to the companies will have to respond to an ADR that will not go beyond 20 working days, but they extended this period to 30 days in complex circumstances or cases. And we wanted to thus reduce the situation and providing this safety to the consumers, among other things. We wanted to encourage the participation in this, and therefore it is foreseen that the members for the consumers and the enterprises can be financial or non-financial. Furthermore, and finally, the agreement says that the exchange of information between the national consumers in the national authorities and the ADR entities that are not commercial should be done in a non-repetitive way. The complaints include information about practices and terms such as unfair practices, and also, as a matter of transparency, the ADR has to provide information to the national entities that are the ones that look out for these issues. You were asking me what the steps are or what problems do we expect as of now. Well, that would be in 16 months. The transposition will be 16 months after it comes into effect, and the member states will have to publish the measures to comply with Article 1 of this directive. They will have to inform the Commission immediately, and all of the measures will be applicable at 32 months of it coming into effect. The political agreement that was approved in July, and at the Parliament we will adopt this revision of the directive in the plenary meeting in Strasbourg, and thus we will end the legislative process. Thank you very much. Thank you. Laura. Laura. I don't know if you have to leave or if you have any time to follow. I don't. Well, unfortunately, I have to leave. So I'll remain just listening to the next speaker. But what I would like to say is that since I cannot stay for questions and answers, I would like to say that my office will be open to respond to any question that you may have in writing, and the email is available on the Parliament website, and Rosa, I'm sure you have it. So if there's anyone that has a specific question or comment or idea that you want me to see, well, my office will be open and but happy to have a session with anyone that needs it. So thank you very much, and I'm sorry that I have to leave. Thank you very much, Laura. It has been a very long process, and you have summarized it with the key points very well. Now, let us move on now to the first intervention of Aida from Lithuania, and we continue to be on this roundtable about the present and future of conflict resolution. And it's hard for us to say her last name, but she is Assistant Director of the State Service of Protection of Consumers in Lithuania. She has a broad experience in the protection of consumers, and she professionally is very much focused on the resolution of conflicts and ADRs that have to do with consumption or commerce, and conflicts that come from online services. There are issues, there are resources. She has worked together with cross-border initiatives and has also been involved in the promotion of different regulations for online processes. So I would like to ask you the same as I said to the colleague from Portugal, Fernando, if you could give us a summarize of the main characteristics of the ADR system in your country, and if you can explain a bit about the authorities that evaluate, that control the ADR systems, and in this case, of course, in Lithuania. So Aida, whenever you are ready.
Buen dia, everyone. I hope my pronunciation is correct, even I don't speak Spanish, unfortunately. So, good day, everyone. And first of all, I would like to start from several thank you. First of all, thank you, Rosa, and all the Consumer Protection Agency of Catalonia, because you speak about a very important thing, about enforcement on consumer redress, and meetings, conferences like that really boost interest in this topic. Second thing, please accept my sincere condolences for your loss. But still there is a hope that people who started these actions are alive between us, and their work is very valuable for other generations as well. It's very complicated to talk about consumer protection system and our traditions. Then we are a very small country, 2.9 million of population, somewhere northeast. Usually our capital is mixed with Riga, and it's normal. But we had a chance, being created in 2001, to be very, very fast, to follow what European Union says, what other countries talking about consumer redress, consumer protection issues. And first steps were done to create some kind of alternative dispute resolution methods were done in 2006, 10 years before ADR directive, and it was really not so new as for other countries, as I was a part of delegation in European Council discussing the first draft of ADR directive. And we really passed a long way, even it's just 24 years, adopting our alternative dispute resolution system to our consumer needs. And last week we did the last session of revision, what we are doing well and what we could do better in this alternative dispute resolution way, because it's totally state-owned We have 5 institutions, state institutions. They are not courts, we are budget agencies, and within our functions, we have commissions investigating consumer complaints. So for finance, Lithuanian Bank takes care. For some energy sector, we have specific institution. And for communication sector, broad one, also there's another institution. But 90% of all consumer complaints come to State Consumer Rights Protection Authority. We are covering all possible sectors, not all involved in the rest. Why consumers like this? Because it's totally free of charge, and both to consumers and businesses, they really feel very comfortable about it because they receive wonderful final decision, binding decision usually. In our case, it's binding decision, and if no one goes to the court, bailiff can go and get your address, your amount of money straight to your bank account. So business is not very interested to invest in some alternatives, and state carries on. When consumer can come to our institution, then the amount of the dispute is just above 20 euros, and there is no ceiling. So from shoes to house. Car vehicles and other possible sectors like tourism, like all possible goods and services you use every day. And having in mind that we have really not a lot of people in our country, last year it was almost 11,000 of consumer complaints which we received and investigated in our institution. And it was around 4,000 of compulsory binding decisions. Having in mind and comparing to the court's workload, it could be like we had in Lithuania last year 155,000 civil litigations in the courts. And from that amount, concerning consumer issues, just 100. 100 we know about it. So our parties are very happy about it, and if there is a misunderstanding or business is not participating in that procedure, that's fine, they can go to the court, but this is not appeal of our decision. It's just totally new civil litigation in the court. So no one appeals nothing, we just have a right to go to the court already using the quasi or out-of-court dispute resolution. Average of procedure in our institutions is 47 days. I guess it's relevant enough. It's free of charge. Our institution is very active in collective evidence. So it's also very nice that for traders, we collect evidence. Traders are not obliged to take part in the procedure, but also it doesn't stop the procedure ongoing. I mean, if consumer complains to the trader, he or she answers to his or her complaint within 14 days, or there is no answer at all, and for that you can get a fine, according to our totally different procedure. Up to 5,000 euros, they come to us. Then they come to us, it's very convenient because 72% of all complaints, they are like presented via our national consumer protection IT system. So literally people like after some dinner, they got a parcel of defective good, and during nighttime we send us a complaint because it's very convenient. You just browse, you just add your photos, videos, whatever evidence you have. So we receive and we start investigation. It's also very important to say that we really try to mediate between parties, and this is the goal and the main task from the government we receive, because in each document concerning consumer issues is a key word to seek for social amicable solution, for win-win situation. But in many cases, there is just application of law, because we evaluate the consumer's complaint is reasonable, it's based on law or not. So after that procedure, we receive a binding decision, and they decide to go to the court or not. But in many cases, when they go to the court, half of them, we reach amicable decision. So what's next in our situation? Because you talked in our panel about cost. For consumer and for trader is totally zero. I mean, you don't have to be represented by the lawyer. You can come yourself and just present your mother or your brother, whatever. No one really asks you to be represented. So it's very consumer friendly. But then you compare a consumer dispute of 20 euros and how much the state spends for it. It's an average of 350 euros, like an average, depending on the situation. But there are very serious cases when we ask for expertise on the favor of parties. So as I said before, we are very active in collecting evidence for both parties, by the way. So we also have to inform about each other as a decision to go into the negotiation or not. And finally, the decision is made. So it's free of charge, no lawyer, quite relatively short terms. It's very easily accessible on IT manners. What can we do more? So we also involved in that some artificial intelligence instruments, like, some drafting of our decision, because workload is divided to 30 people in the office. It's not that easy to deal. So we are really rethinking about the procedures. We're looking forward about some amendments ADR directive will bring, but sincerely thinking for our model, it won't be so many changes, because still we have wonderful, very soft, sweet, and well-functioning system for business and consumers. We really like it. So that's from me, and I'm looking for your questions.
Sí, yo, gracias. Perdón.
Thank you, Taida. And before going on to questions that we may have in the audience, I would like to ask them, ask a brief question to Fernando and Aida. I understand that the average is 57 days in Portugal and 47 days in Lithuania. Well, that is remarkable. Also, if we take into account a staff of only 30 people in the case of Lithuania. But I would like to know how you evaluate the process. For example, how have you seen the evolution that you've explained? How would you evaluate that? And if you're reaching the expectations that you had, do you think that the adaptation to the new directive of resolution that Laura Ballarin has summarized in her presentation, do you think it will affect this very effective system of yours in a relevant way, or will they be obstacles that will make it more difficult? We're talking about a 32-month period for adoption, and that's a long period to adapt. And for Aida, I would ask the same question. If you think in this sense that the consumers as relates to the issue of mandatory participation of the companies, I see that the situation in Lithuania is a bit more mixed. But what is your evaluation as far as the efficiency, effectiveness, and efficacy of this participation? So, Fernando, would you like to begin?
Well, Jean Caléolois, an eminent French jurist, that I like particularly, said following at a conference held in Lisbon in 1992, "It is not enough to make laws to protect consumers. Consumers must also be given the means to enforce their rights. If these means do not exist, consumer law will be nothing more than a theoretical matter with no practical application." I never forgot those words. Although our system allows for the full enforcement of consumer rights, it is also very important for businesses, as I said, in that it has forced them to become more efficient. The behavior of companies towards their customers is completely different from what it was before arbitration became mandatory. In this way, we have been able to guarantee resolution rates of 95% in the most efficient consumer courts and average resolution times of 31 days in cases relating to essential public services. In summary, in Portugal, we currently have mandatory arbitration for companies providing essential public services, companies supplying goods and services to consumers with a value up to 5,000 euros, and companies with full membership for cases with a value between 5,000 and 300,000 euros. Considering that the vast majority of cases fall in these categories, and voluntary arbitration applies to a handful of cases. About the impact of the new directive on our system, I don't know yet what were the impact of that. Okay.
D'acord. Gràcies. Aida, com vulguis.
Aida, whenever you wish.
So what I would like also to stress out, responding to your question about future and also present, I would like to say that enforcement, and totally 100% agree with my colleague next to me that enforcement is very important and consumer redress is just a part of it. So our approach is now that even it's simple dispute, like civil dispute between trader
Disculpa.
and...
Sorry, Aida. El canal, la traducció català, sisplau. Funciona? Ara sí? Thank you.
Okay.
Go ahead.
So even if it's just a civil dispute between consumer and trader, there's always some breach of law, like unfair commercial practice, like unfair contract terms, or maybe dangerous goods. And we really evaluate each consumer complaint like this. If we can go on this enforcement in other sectors, and we are happy that we are a consumer ADR institution, we are a tourism market surveillance institution, non-food products, also market surveillance institution, and responsible for the rest of consumer law. So we can have all approach in one hand, and with that way is very important, I guess, because our consumers are really going to the third countries, and I really believe that we will take that opportunity to protect them outside Europe, because now it's Lithuanian consumer, Lithuanian trader. Otherwise, we use ECC net services in case of international contracts. So we will get some kind of instruments, hopefully, but there is a question of enforcement of our decision then. And it's also important to teach our consumers. We really went to the direction of average consumer and its definition formed in the case law, but now we are turning back to the vulnerable consumer, and it doesn't matter on your education, it doesn't matter on your incomes. In each situation, you can become vulnerable consumer. For example, maybe you heard that we have a tax from Belarus, then some tobacco parcels like balloons are flying to our country, and that affects airlines. It means consumers lose their flights, consumers lose their holiday, and even it's kind of criminal action, it's totally connected with consumers. And we can't say that this is just a civil matter, it's all about everything. So I guess it will be more and more complex, having in mind artificial intelligence issues, even we also try to follow them, but consumers are tricked. Our Lithuanian consumers taking price and cheap price for the good versus sustainability. And this is really a long way to go because of some economical issues as well. So I really hope that like transposition of this ADR directive into our national law will help us to correct some principles and some procedures, but still, as someone from the last panel said, the law is too late. It had to be already done before, and we are very slow with this creation of rules. So I hope we can be quicker. Thank you.
Molt bé, gràcies. Aida,
Thank you, Aida. Yes, the issue of cross-border commerce. We all know it would be a utopia to think that the borders are not there. We have cross-border commerce through internet, and there are many issues that seem to be very intuitive for the consumers, but often we are working with companies that are outside of the European Union, and that can cause difficulties. In this sense, it's true what Ms. Ballerin was saying, that the directive began very strong, trying to cover not only companies inside the European Union, but outside as well. And finally, it has turned out that an adhesion, a voluntary adhesion to those outside, as well as the consumer themselves, should voluntarily join an ADR, arbitration, mediation. We know that each country has their own system and their own mechanism to do so. I would like to ask if there are any questions in the room, anyone that has a doubt that would like any kind of clarification, and to take advantage of the presence here of our colleagues from Lithuania and Portugal. Yes, there's a question there. Uriel Sanchez. Hello, thank you for the explanation. These are two questions. One for each one. First of all, for Fernando, and that is in the case of mandatory arbitration, in the case that this were to exist for the consumers, how do the consumers know that they can turn to this channel? What dissemination do you do towards them so that they can be aware of this? Because there are many people that say that during 2024, and given the population, which is similar to Catalonia, it's a bit low in proportion. So do you carry out any kind of campaigns or any dissemination of this information? And the question for Aida, within the Lithuanian system that we've seen as a voluntary one, how would the Lithuanian population see a mandatory system for basic situations, or do they think it should be broader than that?
La primera pregunta, si la pots repetir per...
Could you please repeat the first question for Fernando, please? So what are the dissemination campaigns that are done so that consumers get to know arbitration and they can decide whether it becomes mandatory for companies? Apologies, but I believe he's not using a microphone. Apologies, I'm told that we can't hear Catalan.
Of the information of our service for consumers and traders in Portugal. Because when the system begins in 1989, and we create the first consumer court in Lisbon. Everything begins in Lisbon, in Portugal. And next in Oporto and Braga. Each service work for its jurisdiction, is territorial. So we don't have a national brand service image, you see? We work just for Braga or just for Porto. So this concern, this preoccupation begins in the translation of the directive ADR in 2013. That's when we begin to create a national brand image. So now we don't identify as like a Center of Information and Arbitration of Braga or Center of Arbitration of Consumer Conflicts and of Lisbon, because this is, for consumers, this is very confused. That don't help to create a national brand image. So now we just identify all the 7 courts on the mainland by consumer courts of Braga, and this begins in 2023, and I think with the time we go, we will still have more exits and more process, because in Portugal we have an institution who helps since a lot of time ago, is DECO, the National Association of Consumers. And since that, even today, when consumers are in our service, they think they are at DECO. So we are not DECO. We are courts, impartial, independence. We are not, we must effective the rights of consumers, but in the way courts must be judged that question, that issues, not like a consumer association.
Gracias. Aida?
Thank you very much, Aida.
Of my colleague, and if I may also answer, even I was not asked about it, we really do a lot of information dissemination for consumers, because if you ask them on some opinion polls, do you know where to apply? So some of them say yes, some of them say no. But if we have this one-stop shop IT instrument, as I said, internal IT system for consumer complaints, it's easier for them to navigate and to find the answer. So what we did the last year in December, so we just presented umbrellas in bus stops, and it's like protection of consumer rights in each bus stop, in Vilnius, in other cities. And it was also QR code how to reach our IT system. It was fun, and the newspapers also got quite interested in our message, because you should look for different ways. For school children, there's another way. For elder people, we have meetings. So it's always continuous searching for the correct information dissemination method and tool, because it's quite difficult to reach them, but if we want, they can find us anyway. And answering to my own question already, I could say that if it would be mandatory for parties, especially for traders, to say, yes, I will go into the ADR procedure, not the court, it would be miles away for us back. Because now we can investigate and settle consumer dispute also on the evidence consumer, and we as institution collect. There is no need for trader to say, yes, I am in, or I am a part of a dispute. If you are not active, you was invited, you was informed about your possible rights, and the end of a procedure, what kind of product it will bring. If you are not interested, so we don't care. We go with the decision on the favor on consumer usually, also based on evidence, not just on our idea or imagination. So it's very strictly based on civil code, on law, on consumer protection, and other sectorial legal acts. If it would be like a favor of trader to be a part of this process, it would be totally stop of our efficiency, because they would say no. we go to the court and consumer don't want to become defendant or plaintiff in different ways. It's very painful for them. You have to be represented there. It's not enough to be represented by yourself. You have to go to seek for lawyers. So in that case, it would be kind of, it's my opinion, personal one, that it would be really back forward. That's it from me.
Sí, Alicia, muchas gracias. Bien, voy a hacer
Okay, so I will ask a common question for both. The first for the director of the Arbitration Center of Braga. I believe that everyone who's participated in the implementation of consumer arbitration in Spain have gone hand in hand with Lisbon, because we are the two European, sorry, not Lisbon, but Portugal as a whole, because we are the two European states that have opted for arbitration as a conflict resolution mechanism. I've shared many years of discussions with Isabel Mendez, so I know perfectly well, I know consumer arbitration in Portugal really well. My question is for you, Mr. Viana, and is, as far as I know, and I hope this is not changed, the decision of making participation in arbitration mandatory for service providers or companies has not been taken to the Constitutional Court of Portugal. Do you honestly believe that there would be a fit between that decision in the Portuguese constitutional order? Do you believe that decision would fit the order?
In Spanish, it's not easy because normally I speak in Portuguese. Well, I know that in Spain that is a constitutional problem, but in Portugal, our system, our arbitration system.
Perdona, Fernando. Approach the microphone.
In Portugal, our arbitration system is similar to the judicial system. It means until a process of 5,000 euros, they cannot have, you cannot
recurrir
of the decision. It's the same thing like the judicial courts. Up to 5,000 euros, you cannot make recording of the decision in Portugal. It's similar like in the arbitration court. I think the consumer courts are in Portugal are really the people courts, and the answer of the other table, the judicial system does not respond to consumers, does not respond at all for consumers' problems.
Yeah.
If we don't have our system, developed our arbitration system in Portugal, consumers will lost every day. They simply don't go to justice because justice is very expensive, very complex, and the duration of process is very, very long. So we have now, I think, one of the most efficient system in Europe for consumers. If I said Portugal is the paradise for consumers, no, we still have problems. We have funding problems. We have a brand image problem. We need an electronic platform for consumers and traders can see the process in their platform and can work with this, put documents in that platform. The electronic platform we have now, it's many years ago, it's completely don't give the minimum of standards, of legal standards. But I think we have best results and the system is very efficient. And I think we don't have the same problem as you have with the Constitution. We don't have that.
Bueno, con el Tribunal Constitucional, de momento. Okay. De acuerdo. La segona pregunta per la...
The second question is for Aida, because we have 5 minutes left. Oh, so are you really optimistic vis-a-vis this extension of the application scope of the directive, of the ADR directive for third countries? So do you believe that companies in third countries will subject to this? Do you truly believe that decisions will be executed? Honestly, I am more of a pessimistic person regarding that.
Thank you. I totally agree with you, but I still have hope that at least some companies would be more reachable. We had wonderful case with Panama, which is far away from Europe, and we were a center of misleading of consumers' practice. We a Lithuanian company with some intermediation in Poland, really fraudulent products to Lithuanian market. And thanks for ISPEN, International Consumer Protection Network, we reached that company using these contacts. If it would be a kind of base of law, to reach some of them would be easier. But as I mentioned before, how they enforce the decision. Maybe we will change practice, and we saw these kind of things that we changed practice if we find them somewhere, especially in e-commerce issues. But still, at least it would be different answer to consumer. But we took this direction to educate them. Don't buy outside Europe. If not, we are really not able to help you. And we are talking not about hundreds, but like millions of euros they lose every year, especially in China and other third countries. So I don't know. And yes and no, but I'm sure these companies, if we have this kind of instrument, will change their practice somehow. So hopefully for the best of our consumers.
Solo añadir, si me dejan, que el problema es más grande.
I would only like to add that the problem is even bigger with the resolution or the expansion to third countries. And this is bigger for those countries that have gone for arbitration because it's much, much more complicated. I can try and answer in, well, half Portuguese, half Spanish. We copy the Spanish system back in 1989. We copied it. With 3 differences, perhaps, because your system is public, ours is private. The Spanish system had 3 arbitrators. We only had 1. The decisions or rulings of arbitration boards in Spain are based on equality or equity. And microphone, please. And ours are only based on law. Equity is just an exception of this system, only allowed if the different parties request it. So truly, we don't. I believe that we have properly developed our system. We used to lag behind you, and I believe that we are now slightly ahead. Our experience tells us that the system is fantastic for consumers and users as well as for companies because it is fair and it is true quality certification for companies. I've been in the system for 30 years now, from the very beginning of the system. and I have accompanied the system. And the behavior of companies today has nothing to do with the behavior of companies in the past. In the past, when arbitration was voluntary, when we notified a company about a claim, the response was, we are not going to go to the arbitration court. Companies and lawyers, that's the answer they gave us, and they wanted to have nothing to do with us. But since arbitration became mandatory in 2011 for essential public service litigations, and then in 2019 for disputes of under 5,000 euros, the behavior of companies absolutely changed. But I am a mediator, and mediation in our services solve the majority of the issues. Over 80% of procedures are solved through mediation. And in my opinion, mediation is the best thing for consumers and companies. It is a process of self-responsibility and accountability of the parties, and not to just go to a third party for a resolution, which oftentimes know nothing about the conflict, and there'll be an ill resolution. This is what happens in arbitration, but also in judicial courts with judges. Thank you, Fernando. And thank you, Alicia, Aida, Elisenda. If you wish, we will now close this session. We'll close this round table. It's been a fabulous table, so a big round of applause. Also, Rosa Jimena, thank you very much. Aida, Fernando, thank you so much. And there's lots of things we can talk about. Tomorrow we have a second session, so we will continue speaking about all the things that we mentioned today. We have 3 roundtables tomorrow, so many things to touch upon, and hopefully you will continue participating as you did today. Thank you for your attendance, thank you for your participation, and tomorrow, whether it's online, through streaming, or in person, we will meet together at 9:30 in the morning to continue with the second session of this 4th conference on consumer arbitration. Thank you very much.